Please hand over the slip. Yes. Tomorrow is the date fixed for what? What is the impugned order? What is the impugned order? What is the nature of the impugned order? Please say what is the impugned order. Please hand over the slip. Yes.
My mentioning.
Mr. Das, I have asked you to hand over the slip. Yes.
My 14th judgment will be delivered. Before that matter has been taken.
Hand over the slip. Yes.
Minus extension of stay minus
Extension of
stay order.
Chatterjee, please.
Here is 1 minute. I have filed the suit. In 151 application, the judge allowed or start the other portion. Even may not before another 151 application, they have police report. But take it up tomorrow, otherwise my that's suit and revision will be.
Hand over the slip.
Take it up tomorrow, may not time.
Yes.
Right, 2026 includes this new motion.
Hand over the
So
slip.
I am mentioning one application. Suit for partition,
Application.
my lord.
Hand over the slip. Yes.
Only one thing that before, if it is commenced to your lordship and before 14th, a suit for partition, eviction of a licensee has been sought for.
May I permit to mention a matter, my lord? It's a civil revision 1749 of 26. The main appeal is pending before the DRAT for since 23, my lord. The whole compliance has been completed, my lord.
What do you want?
I want a urgent hearing, my lord.
Your
Please
lordship.
mention the urgency. Hand over. Yes, Mr. Vice.
My-
Madam, is he junior or senior to you? Please maintain the decorum. Yes.
My lord, I owe an apology to your lordship. My lord, while my lord was sitting, my lord, in courtroom number 19, 2 matters were assigned to your lordship. My lord had taken up these 2 matters. My lord, it has gone down, my lord, in one of the orders that, my lord, there is an application under Order 7, Rule 11 pending. My lord, so I must have been, my lord, under a wrong impression.
Dismissal of the suit.
Yes, not Order 7, Rule 11.
Yes.
So, my lord, may it appear as to be mentioned. And, my lord, one more thing, my lord, I am told, my lord, the order, my lord, came in the server a little late, which is why, my lord, the opposition which we were, my lord, supposed to file, my lord, that could not be
In
filed.
objection to the application for
By
dismissal of
3rd
the
July.
suit. Page 3 it has been mentioned.
My lord, in the other order, my lord, it has gone down as Order 7, Rule 11 application.
Because at that point of all right. Can you indicate where in which order?
My lord, I will do that if the matter, my lord, appears as to be mentioned
To be
tomorrow, my
mentioned
lord, I
tomorrow.
will indicate.
Yes. Please indicate where it is to be corrected.
My lord, may I
Ye
be
din
permitted?
যেটা আসবে আমি সেটা দিয়ে দিচ্ছি কোনটা আসবে না?
My lord, may I be permitted to mention a matter for inclusion in the list, your lordship? Your lordship, my 151
Under
application.
what heading?
Your lordship, new motion, your lordship.
Hand over the slip. Yes.
Deeply obliged.
Therefore, my lord, application next date is in 29th July. Any day prior to that, my lord, my evidence will be closed.
Please indicate the urgency. Hand over the slip. Yes, ma'am.
The matter pending monthly list of June, item number 1004. My lord, petitioner is a very sick, my lord, and senior citizen. My lord, kindly upgrade this matter is very urgent.
What is the impugned order?
I do.
Please go through the brief, then mention.
May I have your lordship's kindly to mention item number 55 of your lordship's statement. The urgency is that my receivables from the National Highway Authority has been attached by a civil judge.
Item number 55 of the supplementary list.
My lord. My dear, the only
What do you want? Upgradation?
upgradation of the only thing
Not possible. Yes.
বলছি স্যার
Possible. Upgradation from the monthly list.
for which
From the upgraded matters.
it can be done. If I can
Please don't hand over.
বলছি স্যার আগেও 2বার মেনশন করেছি পিটিশনার ইন পার্সন আমার লোয়ার কোর্ট থেকে একটা টাইটেল এক্সিকিউশনের পুলিশ হেল্প রিজেক্ট করে দিয়েছে
Mention করেছেন তো mention
হ্যাঁ স্যার ওটা স্যার কালকে ডেট রয়েছে ডিসপোজ অফ হয়ে যাবে স্যার
My lord, kindly don't fix me amiss, my lord, for release, my lord, since Mr. Chakraborty is appearing in Baru.
which Mr. To be mentioned.
Your Lordship, kindly, if I may be permitted to mention a matter for filing without the certified copy of the impugned
The
order.
urgency.
Your Lordship, the 2019 petition pending before the tribunal Lordship, there have been multiple occasions where the matter has been taken up, but it has not been heard. I'm only praying for a direction to be passed for expeditious disposal.
Expeditious hearing, there is no urgency. Please obtain the certified copy. Then file.
Your Lordship, Your Lordship, if you're kind, Your Lordship may appreciate, Your Lordship, with the 2019 matter, there are serious allegations of oppression
How
mismanagement.
much time it will take for the certified copy?
Your Lordship, at least a week or 2 weeks. The order was just uploaded on the server. If I may
No
be.
problem. Please obtain the certified copy. Then file. In all matters, it cannot be dispensed with.
Item number 448 of today's list, my lord. I am the PMT. I lost both the court in court below. Lord, I preferred an civil division application, but
No, I could not follow. Yes.
I am the PMT, man. I am the PMT, my lord.
Please use the microphone.
I am
the preemptive.
PMT, my lord. I lost both the court in below. My lord, I preferred an civil liberation application. This is item number 458, my lord. Lord, execution is pending, my lord. Police help has been allowed, my lord.
Preemption on what ground? Preemption on what ground?
Co-sharer, my lord.
Co-sharership.
Yes, my lord.
Both the courts, what remains?
Lord, I preferred, I moved these to PM, my lord. My lord, I
দিয়ে দিন ওটা কালকেই দিয়ে দেবো। Yes.
May we permitted to mention a contested application? It was
Contested, please wait.
Milord, may I only say this, Milord? Though it is a contested application, other side is not appearing. Milord, it's Kamarhati municipality. Lordship passed an order, Milord, 1.5 years back. Milord, thereafter tried several times. Notice
Sir, motions are there. You see upgradation of the upgraded motion.
Milord, only this is, Milord, I am the
Please wait because it cannot be held. Because
I am the landlord, Milord, and this is suit for eviction.
Yes.
Lordship, may be permitted to pray for leave to file this application. Lordship, on the verge of your Lordship state the entire
You
process.
want leave.
Lordship, as because it is very much urgent, Lordship.
File it will appear. No leave.
My lord,
Please file it will appear.
my lord, I am for the why maintenance matter, my lord. Lordship, your lordship admitted the matter.
Motion.
My lord, no, my lord, you already admitted, my lord. 2144.
Contested application.
2144, ma'am. My
Please
lord,
wait.
in the year 2025 matter, my lord.
I appreciate, but please let me take up
In the month of August, my lord.
Please wait. Yes.
Lordship,
Call the list.
One matter, Lordship. Is there for upgradation, Lordship, that tomorrow is the date?
Please hand over the CPS.
As early as possible.
Pass over. Yes, next.
5 and 6, Mr. Bhattacharya is appear.
Since I'm not inclined to take up this matter on personal ground, the matter stands released from the list of this bench. Let the papers be placed before the Honorable the Acting Chief Justice for necessary orders. 5 and 6, same order. Next. Yes.
Lordship, in the order, see, Lordship, paragraph 4 and last paragraph, third line, Lordship. In place of junior division, it has been recorded as senior division, Lordship.
Should be junior division.
Yes, Lordship, only junior division.
Which page?
Lordship, first para, fourth line, and last para, third line.
First para, fourth line.
Yes, Lordship. And
Instead of senior division, it should be junior division.
yes, Lordship. Only
Third court is right. And what is the other correction? Which page?
next page, Lordship, third line, last para.
It has been pointed out that in the order dated 30th of June 2026, it has been wrongly recorded as civil judge, senior division, third court, Paschim Medinipur, instead of learned civil judge, junior division, third court at Paschim Medinipur. First of, let such errors be rectified. This order shall form part of the order dated 30th of June 2026. Yes, next.
8, 9, and 10. So what is it?
8, 9, and 10 released on personal ground. Next.
So I will be petitioner, my lord. Several times I mentioned earlier to get the matter appear under the heading extension incident order, but matter could not be appeared. Evidence I have served
Several times you mentioned. When? Not before this bench. Yes. Yes, sir. The interim order is still end of April.
These two.
Who is for the opposite party?
I have served the copy from the opposite party side. There is a direction materially appear on 1st April for hearing.
Every service filed in court today is taken on record. Mr. Ghosh, learned advocate, appearing for the petitioner's appeals that the opposite parties have been duly served. First, in spite of service, none appears to oppose the prayer for extension of the interim order. First up, after hearing Mr. Ghosh, learned advocate for the petition, the interim order is extended till the end of the month of November 2026 or until further orders, whichever is earlier. Yes. Next.
Next one is same, my lord.
Next is also same.
Yes.
Expired in April. Mr. Ghosh, you did not take.
Kindly forgive me, my lord.
Other side has been served, opposite
Yes,
party.
served.
Same order. Next. Call the next matter. 13, yes.
I'm for the petitioner, Lordship. This is an application for expeditious disposal, Lordship. Lordship, allows I will come back after serving the parties.
Want to serve the other side?
Lordship, this is merely a petition for expeditious disposal, Lordship.
What is a suit or any application?
Lordship, suit, Lordship.
What is the stage of the suit?
I'll just apprise.
Seven 7172 disposed of.
Lordship.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff, praying for a direction upon the learned civil judge, Junior Division, First Court at Barasat, to dispose of title suit number 933 of 2023 expeditiously. First up, the learned advocate appearing for the petitioner submits that the suit for eviction is pending from the year 2023. First up, paragraph in view of the order sought and proposed to be passed. Next, from the order sheets appended to this application, this court finds that a date of hearing of the application under section 7 within bracket 1 and 7 within bracket 2 was fixed on 30th of was fixed 30th of February ki kore hobe 7-1, 7-2 and 7-3 of the West Bengal Premises Tenancy Act was fixed for hearing on 3rd of February 2026. First up, paragraph in the light of the submissions made by the learned advocate for the petition in view of the order sought and proposed. In view of the order sought and proposed. Next, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge, Junior Division, First Court at Barasat to make an endeavor to dispose of the pending interlocutory applications as expeditiously as possible without granting any unnecessary adjournments to either of the parties. First up, after disposal of the interlocutory applications, the learned trial judge shall make an endeavor to dispose of the suit expeditiously. Next. Yes.
Defendant is the petitioner before my lord.
Yes.
My lord, defendant, my lord, I am the beneficiary.
For the defendant.
I'm the defendant.
Yes.
My lord, I am the beneficiary.
What is the input order?
My lord, before that, my lord, impugned order, my lord, I filed an application.
What is the impugned order?
For maintainability of the suit, my lord, that was rejected by the order impugned.
What is the stage of the suit?
My lord, that injunction petition not yet been, my lord, disposed of. My lord, what is my ground? My lord, I am the beneficiary under the Homestead Act. Now, my lord, challenging my homestead recording, my lord, another proceeding is pending before the learned tribunal. Now, on the same plot, plaintiff filed a suit for declaration of their right title interest over the same plot. Now, my lord, under section 12 of the, my lord, the Homestead Act, my lord, there is a bar for the learned civil court.
Babu Sarkar.
My lord,
The book author.
Combine all.
Author.
No, Babu. My lord, combine.
What is the name of the author?
My lord, the all acts are मतलब the amalgamated here मतलब that is मतलब I am the occupier under
Section 12.
Section 12 is the bar of the landed civil code. I am the occupier under section 4. If now the section 9 reference or now he has to file a section 9 reference. Now the challenging.
Yes, what is the reasoning of the Landed Trial Act? Please show me.
First time the initially I filed a maintainability petition that was rejected by the Landed Court below. Now challenging that a revisional application was filed before this honorable court. Now that revisional application
Maintainability on the same ground.
Same ground.
Then Mr. Ghosh, what happened in the revision?
Revision withdraw direct to raise all these issues. Without setting aside this one, kindly
Then Mr. Ghosh, how the second revision is maintainable? How the second application was maintainable?
kindly
Please show me the earlier order of rejection of maintainability application and the order in civil revision.
Now, the order dated 10th March 2023.
Same ground was taken.
That is the
Mr. Ghosh, all points to be raised before the trial court means at the time of hearing. This application under Article 227 of the Constitution.
Only one thing, kindly comes to the land in the divisional court, give a liberty. All the issues have been left open. The land at trial court shall dispose of the matter expeditiously. Although there is no.
So that means again same application can be filed. Is it your interpretation? I am interpreting that order. This application under Article 227 of the Constitution of India is at the instance of the defendant.
That preliminary issue, the preliminary issue,
that application, Mr. Ghosh, you should have canvassed before the coordinate bench when the earlier revision application came up. You should not have withdrawn that.
That is.
Then, if you have withdrawn, end of the matter. This application under Article 227 of the Constitution of India is at the instance of the defendant and is
Lordship, I am for the petition, Lordship. This is also a petition for expedition.
Again, expeditious.
Yes, Lordship. Unnecessary delay has been.
Suit. What is the suit?
Lordship, this is
Suit for
eviction
men's
suit.
profit.
No, Lordship, men's profit. Lordship, under the Premises Tenancy Act.
It's not an eviction suit.
No, no, Lordship.
What are you saying, sir? 7-1 same order. একই তারিখ ফারিক case of 7172 ছিল. This application under Article 227 of the Constitution of India is at the instance of the
On a plain
Yes.
TV is the
Yes.
TV is the petitioner, my lord, before my lord. Plain TV is the petitioner.
Yes.
My lord, suit for declaration. My lord, I file a suit for declaration that the deed, my lord, by virtue of which my lord, the defending is claiming his right, title interest, that is void. My grandfather did not execute that deed by putting his thumb.
Defendant is claiming through your grandfather by
Yes.
virtue of a deed of gift.
Deed of sale dated, sale of the year 2014.
You are claiming by virtue of inheritance.
Yes. Now, my lord, in that
So
suit,
you have filed a suit, or your
I-
grandfather had filed a
no,
suit.
no. We filed a suit that this deed is void for a declaration. Now, my lord, in that suit, we filed one deed, registered deed, where my grandfather, my lord, put his thumb impression that was exhibited without objection.
Exhibited.
Yes. Exhibit
What is
number
the
3.
number of the exhibit?
Exhibit number 3.
Do you have the copy of the evidence, Mr. Ghosh? Where it was marked as exhibit 3.
My lord, that I have, that evidence copy is not there.
What
in
is the
my-
reasoning? What is the reasoning for rejecting?
Well, the rejection, well, the ground is that not with the admitted document, and I say, since it is a exhibited document and without any objection, I prayed for comparison of the
Mr. Ghosh, exhibited document means there the signature was proved in that.
that is exhibit.
That Mr. Ghosh, was the signature proved by any person?
That is without any objection that was exhibited.
Mr. Ghosh, learned advocate appealing for the petitioner, there is substance in the argument of Mr. Ghosh, learned advocate for the petitioner, that
My lord, actual divorce was decreed with consent, my lord. My lord, 2017, that order was passed, my lord.
Page 19.
19, my lord. Page 19, my lord.
Yes.
My lord, thereafter, in 2026, my lord, wife has come forward before the trial court for maintenance, getting her major son under section 20 of Adoption and Maintenance Act, my lord. My lord, thereafter, I have filed order 7 rule 11. My lord, without
He's not your son.
no, yes, my lord, but he is major, my lord. My lord, major son has come. My lord,
What is the age? What he is doing, son?
22?
Is he earning?
No, my lord. For
You
education
don't,
purpose, my lord, that is true. My lord, I am
After
following.
all, he is your son.
My lord, kindly come to the page, my lord, without.
After all, he is your son.
Yes, my lord.
So
My lord,
20 years son is independent. He does not read the age.
as per court's direction,
You are
my
after
lord,
all
I
a
have
father.
paid. My lord, lump sum amount at a time within 7 days, 50,000 will be paid without considering my application for maintainability, my lord, order 7 rule 11. My lord, without filing any opposition, written opposition, my lord, kindly come to the page, last four page, my lord. First 4 page. This is the impugned order, my lord. My lord, kindly come to the 20 of the Adoption and Maintenance Act, my lord. Without opportunity of any hearing, my lord.
I'm asking you, son aged about 20 years do not require any maintenance.
No, my lord, as per law. My lord, kindly come to the my
Don't
lord.
show law every time. I'm
My lord,
asking you as an
per
officer of the court.
My lord, her application was filed under section 20 of Adoption and Maintenance.
Without the application, you volunteered to pay. No application will be filed.
My lord,
Please maintain him. I record your submission that he will maintain. I reject this application. After all, he is your son.
my lord,
You have a duty as a father, sir.
Yes,
Sir, you
yes.
have a duty as
My
a
lord,
father.
yes, I will pay. But my lord, mother has come after divorce. This is her
You will not pay
application.
to the. You will not pay to the son. Please open a bank account in the name of the son. Pay it to the in the bank account of the son.
My lord, as per honorable.
That I don't think you do not have any difficulty.
As per court direction, up to the age of 18, 10,000 regularly I have paid.
You are paying.
Yes.
10,000.
Yes, my lord.
All right, serve. Petitioner is directed to serve a copy of this. Now, the learned advocate appearing for the petitioner submits that, in spite of the fact to the son. Yes.
The
Yes, Mr. Ghosh.
plaintiff degree holder, the petition, the suit for eviction of licensee degree past 2013.
Yes, trouble starts after the decree is obtained in the execution.
Yes.
That's your trouble.
Now,
Well settled. In Privy Council, it has been made.
the second appeal.
What happened now? What do you want now?
I kindly see that the number of adjournments there. The second
So
appeal.
from bringing stay order from the High Court, why? Anything is pending.
Yes, then the check. The against the judgment.
Any miscase pending?
No, the second appeal.
Second appeal.
Second appeal is pending under the order 41 rule 11 for admission. They are not taking step. Initially, that was
Matter is appearing in the list.
not appearing.
Not appearing. All right, do one thing. Where is the other side?
What I am serving.
Other side is where?
Murshidabad.
Murshidabad. Please serve and come back. Mr. Ghosh, learned advocate appearing for the petitioner submit Yes.
My lord, this is an application for expeditious disposal of a suit for eviction. This is a suit of 2020.
What is the stage of the suit?
Nothing has been done, my lord. Only 7171 applications have been allowed. The commissioner was appointed in 2023. His report was filed in 2025 and the report has yet not been accepted. It was supposed to be accepted.
1st of August for acceptance of the commissioner's report.
Yes, my lord. It was
So this is
supposed
an eviction suit under the Visible Premises Tenancy Act.
for reasonable requirement.
This application under Article Yes.
Item number 20, my lord, I'm for the petitioner, I'm paying for passover, my lord.
Yes, yes. What is this matter?
My lord, I'm instructed to take passover, my lord. Learned senior Ovila strategy, he is tagging code number 19, my lord. My lord, kindly make it short passover, my lord.
Pass over next. None appears for the petition at the time of call. No accommodation. Yes. So I am
This is the prayer for early disposal of the partition suit. The petitioner before Lordship is the defendant.
Early disposal of the partition suit?
Yes. Since 2008.
What is the stage of the suit?
Lord, nothing has only one injunction order has been passed in order 13 in 1 and 2. That has not been disposed of since 2008. The defendant already appeared, filed a written statement, and also the written objection of the order 13 and injunction petition.
7th of April 26 was for order 22 rule 4. Substitution.
That is my last occasion. My lord, this since 2008.
Substitution application allowed.
Substitution application, only one substitution application is pending. That should be disposed of.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction. Plaintiff or defendant?
We are the defendant.
83, yes.
My lord, praying for a notary, my lord.
Yes, what is
I'm
the
being-
order? What is
I'm-
the order under challenge?
My lord, I'm being led by Mr. Shakus, my lord. He's in a personal difficulty, my lord.
How can you challenge an award in 227?
My lord, he will argue on a point of law, my lord. 1 day's accommodation.
What point of law? Arbitration award. Final award has been passed.
My lord, it's
So
been
227.
my lord, he'll argue on a point of law. 1 day's accommodation, my lord.
Who is arguing? Who will be?
Shaku said, my lord. He's in a personal
Where is he?
difficulty. He's in
He
a
has not
personal-
come.
His father's unwell, my lord.
On the prayer of the learned advocate for the petitioner, the hearing of the civil division application stands adjourned. Next. For the next matter. 25 years.
My lord, I'm appearing for the petitioner, my lord. Mr. Shrijit Chakraborty is leading me in this matter. May I
Please
seek
start,
for
please
a
start.
short passover in this matter, my lord?
It's difficult.
Yeah,
He's a busy counsel. He's engaged in other
my
court.
lord, yes, yes, my lord, with my lord.
Chakraborty Baba, right?
No,
I thought he would be busy.
never busy. No work. No work at all. Lord, on the last occasion, Mr. Mukherjee, Lord, proposed a settlement. The settlement, Lord,
Lord,
the meeting has not.
proposed Milord any settlement. Rather, Mr. Chakraborty has proposed for settlement after Milord receiving the first Milord observation from your lordship. I stand corrected, Milord, if I am not wrong.
I am ready to move.
Settled, not settled.
No, I am ready to move.
Milord, any,
I am ready to move
Milord,
with the
any
matter.
proposal has not yet come
No,
from
if they deny that there is no settlement, I am ready to move with the matter.
Yes.
I was about to say that, my lord, the parties could not sit. If my lord gives an opportunity,
What
we
is the
will
what is
try.
the
I
impugned order?
only Milord reacted because Mr. Chakraborty said the proposal came from me. Milord, my client never Milord instructed Milord to give any proposal for settlement. That's why Milord I have reacted.
What is the impugned order?
Lord, the impugned order. Lord, I just tell you, Lordship, Lord, just
What is the nature of the impugned order?
the nature of the impugned order? My Section 5 application has been rejected by the State Commission. I went to the National Commission. National Commission dismissed my appeal. Lord, a proceeding was
What is
in
the period of delay?
250 days.
The
And
reasons for the delay?
Lord, medical record is there. 300 pages medical record not considered. I was not shifted to my daughter's place. My husband used to look after the litigation. I shifted to New Malipur. They could serve.
The parent dispute.
I tell you, my lord, according to the claim case, Mr. Mukherjee's client entered
The claimant.
into an agreement with me. I just give you, lordship, the date. In 2003, he entered into
car parking space
and flat.
He entered into an agreement with me in 2003. The claim was filed in 2016.
Section 5, Mr. Chakraborty rejected. The court has in exercise
Lord,
of its discretion has rejected why 227 it will
Lord,
be
the
appeared.
proceeding itself could not have been accepted by the tribunal. The proceeding itself is, my lord, a nullity. It could not have been received by the tribunal. Under Section 24A,
you have lost.
I have taken that point. I have taken
Section
that
5
point.
dismissed.
Lord, kindly
Unless
appreciate,
the
sir.
Section 5 is
Lord,
allowed.
if the claim petition could be received after 14 years and a 250 days,
dates, I cannot look into that at this stage.
Lord,
Under Section
I will show your lordship, Lord, the delay portion.
size of discretion, Mr.
Very well,
Chakraborty.
Lord, I'll show your lordships how the discussion
Precisely
has been executed.
one way.
I
Even
will
if
show,
a
Lord,
second view is
Lord, I
permissible, why
completely will not bow
227?
down. But Lord, I'll show your lordships how the discussion has been exercised.
How much cost you are willing to pay?
Lord, that your lordship will decide, but not for the condonation of delay, Lord, anything not coming from your lordship, any cost I am ready to Lord compensate them for 250 days delay. But kindly consider a proceeding which was supposed to be filed. They in their statement of claim.
Show me the impugned order.
Kindly have a look at it.
Yes, yes. Where is the impugned order?
I insisted that we should sit for a settlement. My advocate on record, I don't know why they could not proceed.
Volume 1, page 29.
Kindly come, my lord.
Volume 1, page
29, my lord.
So what is the last document?
Lord,
I'm at the last volume.
14th February 2025.
Yes, 14th February 2025. Yes. Please give me a minute.
14th Consumer Protection Act এনেছো সেটেলমেন্ট বলছিস তোকে মধ্যে এসব বলছিস
ও বাবা তুমি বলছো আমি সেটেলমেন্টের অফার দিয়েছি সেটা তো বুঝে বাজে কথা আমি তো অফার দিই আমার ক্লায়েন্ট আমাকে কি বলবে সে আছে কোর্টের মধ্যে
Not the advocates of both the parties could not sit with each other. That is why I on the last occasion said that my lord send it to mediation. Because the dispute is with regard to
Section
the
5
marriage.
dismissed by the State Commission.
Yes, the appeal, in the appeal.
After that, National Commission rejected.
Both the forum rejected.
Very bad case, Mr. Chakravarti.
But Lord, my case has not been considered at all. Considered at all.
2 courts, 2 forums.
Absolutely not. I
2
completely
forums
bow
have
down
not
to that. I
considered.
completely bow down to that. But my case has not been even considered. Let me show you, lordships, my pleadings. Whether those have been dealt with by the tribunal. Not even dealt with. My medical records are there, Lord. What they did, my husband used to look after my case. Lord, kindly take up my application once at page 431 of your lordship's brief.
So many decisions have been considered. Longish judgment has been passed, Mr.
But Lord, the main point has not been considered.
That's according to you.
I'll show your lordships.
Many decisions have been considered.
জিজ্ঞাসা করে এসো কি চাইছে just because in the medical record it was not written that I have been advised to take bed rest, the court has rejected it.
Rightly so.
The medical record shown, but my case was that my husband wished to look after the litigation. Husband died. I shifted from my house from Howrah to New Alipur to my only daughter's residence, matrimonial house. They could serve me the execution notice to my matrimonial house, but no notice of the proceeding was served post-COVID. So I did not have any knowledge. My husband used to look after. I am a lady, my lord. My husband used to do the business in my name. I am a lady. I could not follow the proceeding. I was not medically well. There have been documents at galore. Only because in the medical document it says that, Lord, I was not asked to take bed rest. That on that ground it has been rejected. Lord, kindly appreciates one thing. Lord, in the statement, the claim petition file, they say that I have refused in 2005. And the proceeding initiated in 2016. The proceeding initiated in 2016. I can show you lordships from the claim petition. They mentioned in paragraph 9, 11, and 12 that the first refusal that I will not accept it came in 2005. Then the date comes up 2011. 2011 refusal, according to them, but filed in 2016. Section 24A comes into play. 24 comes into play.
You are arguing on merits. I cannot
Not kindly appreciates. Not kindly appreciates.
Because you are arguing that unless Section 5 is allowed, merits cannot be looked at.
Absolutely not. But
So
kindly
enter into the
consider.
merits now.
Yeah, a
Don't
meritorious.
prejudice the court by the merits. Please
Lord,
come
it
to
is a
Section 5,
fact.
merits of Section 5.
It is a fact, not a meritorious matter
I
for
cannot go into
250
that.
days delay. A meritorious matter for 250 days delay. Lord, it is not a case. Kindly appreciates, Lord.
Contrary decisions on that.
Yes, there are decisions, Lord, that your lordship would not look into it. Just a Padriwala decision, Lord, I am aware of that. But Lord, kindly appreciates
So
the prejudice that we are suffering.
Meritorious matter should not be thrown out
Kindly take up
on
my.
the ground of delay. There are contrary views of
Yes, yes. Now there are contrary, but those are for those have been rendered in the matters where the authorities have gone up in appeal. Kindly consider that also. The court has also said that the delay has to be calculated from day one, not from the after expiry of the period of limitation. That has also been said by Justice Padriwala in their judgment. But what I am on is that if the proceeding could not have been
explained from the first day till the date of
yes,
filing.
kindly have a look at it.
On the
Those have been rendered in the appeals filed by the
I'm
authorities.
asking you.
Kindly
From
take up the
first day
application.
You have explained.
Kindly take up the application once at page 431.
This is the application before the State Commission.
Yes.
431.
Kindly take up
Yes.
my section 5 application. Kindly allow me to place it before your lordship. কি বললো? কি instruction? বলো কি বলেছে? ঠিক আছে. But kindly take up the applications. Kindly take up the second paragraph. The appellant applicant first came to know about the said order on 21st September 2022. In the first week of June 2023, the order of the district commission is 21st September 2022. in the first week of 23, after receiving a notice from the Learned Consumer Dispute Redressal Commission, Howrah, at her current residence at 23/21, 216A, Ramtonu Lahiri Soroni, New Alipur, regarding institution of execution application filed by the opposite party. The applicant was shocked to come to learn of the same and immediately applied for the certified copy of the final order dated 25 September.
When did you file the appeal?
Lord, I filed the appeal after 250 days.
So from June 2023?
No, from the date of order. Date of order appeal filed. Lord, just give me a second. But would your lordships kindly have a look at page 407?
No, please give me the date when you filed this.
I'm giving you, lordship. Date of order.
Section 5.
The appeal ta filed. Lord, the affidavit page, Lord, it's affirmed on Lord, 11th July 2023. The delay is calculated from the date of the order.
11th of July?
Yes, page 437.
437.
So my knowledge is in June and I filed it in July. 19 July 23. 23. My lord kindly got that, page 437.
Yes.
Now, my lord, kindly, my lord has seen the pleading at paragraph 2. My lord, kindly just to corroborate that, kindly take page 407 once. Now, my lord is looking at page 433.
433 I've read. I'm at 434.
434. Kindly consider para 6 also.
Yes.
Now, my lord has seen the statement at paragraph 2 of the application that the commission has served me a notice.
Please show me the order of the State Commission.
Lord, would you lordship see that later once, page 407, once at page 407. Just come to that later once. Kindly see the letter was addressed to me, Lord Nirmala Devi, wife of Swansu, 23/216, Ramtor Rairisaran, New Alipur. This was not the address on which the claim was filed. So they knew my changed address. When they filed the execution, they must have informed the tribunal about my changed address and tribunal issued the notice. That's my point of knowledge. First knowledge. If the claimant knew it, it was his duty also to serve a notice on that address before getting the ex parte order award.
Where is the order of the State Commission?
Lord, kindly come. The State Commission's order, my lord, will get at page 69.
Page
69, Lord.
Only 69?
Yes.
Why these 5 volumes of civil division?
Lord, those medical records which have not been considered, 300 pages medical records.
300 pages?
Yes. None have been considered.
65?
Yes. 69. None have been considered. Not even one document. But kindly allow me to place this. Along with the
I'm bound by this order, Mr. Chakravarti.
My lord?
I'm bound by this order. Page 69.
But not in the hierarchy now, your lordship should not consider this. After that judgment, now National Commission, after National Commission, we have to come to the regional high court. Then we can go to the Supreme Court now. Earlier, we used to go directly to Supreme Court from the National Commission's order. Yes, now it's settled that we have to come through the High Court, then 227, then Lord SLP. So
Where the initial proceedings occurred, that High Court will have.
yes, absolutely, absolutely. That perhaps to reduce some burden from the Honorable Supreme Court, my lord, perhaps, so that directly from National Commission people don't go, people avail, and to make it also cost effective, economically effective.
Not to the direct point came up.
Yes.
From the National Commission, Delhi High Court was moved.
Yes, yes, Delhi High Court was moved.
Considering the fact that the National Commission has passed an order.
Yes.
There the mentality was raised.
From that, it went
the
to
application
Supreme
was rejected.
From that, it was
Against
moved.
that, an
Yes, yes, absolutely.
SLP said no. Delhi High Court do not have
Jurisdiction, you go to that.
You have to go before the court where
Jurisdictional
the initial complaint was filed.
Altaf ki একটা নাম মামলাটা Jurisdictional High Court you have to go. So, my lord, we are before your lordships. Now, my lord, kindly do not go by the name of the person. My lord, kindly see, my lord, whether this case, my lord, that I ran, that my husband used to look after, and the most importantly, they served me notice from the tribunal in the changed address. How would they know? But kindly have a look at it. Office report submitted, 257 days delay. Having heard the learned advocate appearing for the appellant and on perusal of the record, it appears to me that in the application, the person giving for the reason giving for the delay in filing the appeal is that the appellant, aged about 76 years, has been suffering from respiratory tract infection on and from early 2019, and her health condition has extremely deteriorated over time, and the appellant was also detected with osteoporosis and spondylosis and multimodular and has been bedridden for a long period of time. I have gone through the medical papers, Annex B, and found that there is no whisper in the said medical papers that the appellant was bedridden and she was unable to move. She was advised by the medical officer to take the complete bed rest. Therefore, I find that the ground of delay as mentioned in the application for condonation of delay is not believable, accepted. But kindly recollect that my ground was I was not informed, husband used to look after, husband died in 2020. My date of knowledge is June 2023 from the notice of the tribunal. Now, judgments have been quoted in view of the above. 257 days delay is not condoned. Absolute perverse order. But the ground taken, my first ground was that I was not even aware of the proceeding. I am a homemaker. My husband used to look after the proceeding.
Is going on.
But Lord, that should have been considered. They served the notice in the changed address. In the New Alipur address, they served the notice. And June, my date of knowledge immediately came in July. And I have explained that I was bedridden. I was shifted to my daughter's place.
Bedridden, you could not prove.
I was not medically well. That was the point.
That's the different thing.
The court has said, but I did not in my application say I was bedridden. I said I was suffering from several diseases.
Mr. Chakravarti, it's not that you are suffering from several illness. The question is whether for such illness you could have taken steps or not. That's relevant.
May I say that in my humble
yes.
But in my humble understanding, the question is whether I was aware of the proceeding or not. Question is why they would sub me a notice in the changed
That was your case. Why did you rely upon 300-page medical documents?
But in addition to that, I ran twofold cases. But kindly come back to the application one more time for my satisfaction. Take it one more time. Paragraph 2, I said about the knowledge that it was subbed on my daughter's address.
Consumer Protection Act.
Yes.
With regard to this limitation.
24A. 24A for filing. Appellate হচ্ছে 15. Section 15 is for appeal and 24A is for the proceeding.
24 the limitation.
24A.
The period of limitation has been
for filing the claim, and 15 is the for appeal.
Not the claim.
15 for appeal.
Why are you going to the claim?
15 for appeal.
Yes. So 15.
15. Kindly sufficient cause I have made out. Kindly take my paragraph 4 of my application once.
Any
Paragraph
decision
4.
you want to cite?
My lord.
Any decision you want to cite?
No, my lord, your lordship is, my lord, sitting in revisional jurisdiction against the two courts, my lord, concurrent finding. I can only show, my lord, that the points taken by me has not been considered. There is no single line consideration that, my lord, on the statements made in para 2, para 4, and the other paragraphs. Kindly have a look at that. If my lord feels that those cases ought not to have been considered, then I have no case before your lordship. Kindly come to para 4 of my application once at page 433. Kindly see what the case I made out. Para 3 talks about troubled health. Para 4, the appellant has all her life been a homemaker and the said transaction, etc. were conducted by her husband, and the present litigation was also contested by the said husband of the applicant who expired on 18 July 2020. After the demise of husband, the appellant has been living with her daughter and son-in-law in the address mentioned herein above. Even though the said fact was well within the knowledge of the claimant respondent, no information was ever sent to that.
The complaint was filed against the husband.
No, the complaint was filed against me, but in the address of Howrah.
Complaint was filed against you.
Because my husband used to run the business in my name. That's my case.
So
my husband used to look after the complaint.
No, complaint is against.
Kindly come to page 146.
Yes.
Kindly see the cause title once. Nirmala Devi Agarwal, wife of Swanso, residing at 16/2/1 Grand Tank Road, 7th floor, POPS District, Howrah, 711101.
This is your business address.
This is my residential address also. Right? This is my residential address. I am not aware of this.
But the written version filed by the wife, affirmed by her, address mentioned Howrah. Well, I can say anything, Milord.
Husband used to look
Paragraph
after the litigation.
No, Mr. Chakravarti, I am asking you whether this is the official address, business address, or you reside there.
It says residing. Kindly take the written version that was filed.
Yes. Where is the written version?
Yes.
146.
Just give me a minute, my lord.
163, sir. 163.
163. Yes, written version 163.
Yes.
Point of limitation was taken, not considered by the district forum. Kindly similar the affidavit filed there.
Yes. This you have filed when?
Lord, this was filed 20th February 2017.
20th of February
2017.
2017.
Husband died in 2020 during COVID.
That's an unfortunate event, but only one thing, Mr. Chakravarti. Is it your signature at page 189?
No, there's no denial. We have filed it. There's no denial.
So the person is not through one who was looking after the matter.
But the husband used to look after.
Written version has not been filed by someone.
I signed it. I cannot deny that. The signature is my signature, but the statement in the application that I did not even know the lawyer. Kindly come back to paragraph.
Can you deny that is a false? Can you say this is a false statement on oath at page 184, 189?
It is my signature.
No, not only that. Paragraph 1 of that affidavit.
I am the opposite party instant application, well conversed in the facts and circumstances of the case.
It's a false statement on oath. Please say that.
Lord, my case is that my
you,
husband.
It's a false statement on oath.
Lord,
that you are not conversant with the matter. Everything was handled by your husband. You did not have any knowledge.
Lord,
There is a false statement on oath. Please tell that.
kindly have a look at para 4 again.
So,
Kindly have a look
uh,
at para 4 again. Kindly have a look at para 4 again.
Para 4 is neither here nor there. I'm asking you
Kindly have a
whether
look
it's
at
a
para 4
false
again.
statement on
How-
oath. Yes
How
or
it
no?
has been stated. Kindly see para 4, page 433.
Then you have to say that this is a false statement. Those two are contradictory
Lord,
versions.
Let us
Both
see.
on
Lord,
affidavits.
kindly have a look at whether it is contradictory or not. Kindly have a look at that page 4, para 4. I'm reading it from my lord. That the appellant all her life has been a homemaker. They say transaction were etc. conducted by the husband, and the present litigation was also contested by the said husband of the appellant who expired on 18 July 2020.
That is what I'm telling you.
After the demise of her husband, the
This is
appellant
not
has
after
been
the
living.
demise. This is in 2017. That is why I'm asking you.
The appellant has been living with the daughter and son-in-law.
Mr.
Address
Chakraborty,
mentioned
I'm
above.
not talking about after the death of your husband. I'm talking about the year 2017.
But para 5 of the application.
Yes.
On receiving the said notice and obtaining certified copy of the appellant has
Those are post
Yes.
death of your husband.
Lord,
I'm
my
asking
case
you
is
of the year 2017. So I'm asking you.
I filed a state
No,
defense.
since when you have stopped looking after this case?
Lord, my case is my husband used to look after
Yes,
the
yes.
case. I was a homemaker. He
So
did
then
all
this is
the
a false
transactions.
statement. Mr. Chakraborty,
Lord,
you have
kindly
to state
consider.
those two
Kindly
statements of
consider.
affidavits, which is correct, which is false. Please
Kindly
make that
consider.
statement.
Kindly consider. In my humble submission, these are not contradictory. These are in the second statement. I have explained that, Lord, I have signed as a homemaker. The business used to be run in my name. My husband used to look after the litigation. I may have filed the objection, but this is very common that the husband used to look after the litigation. He engaged the lawyers. Then after his demise, I shifted to my daughter's place. Lord, why would the notice be served on my address, in the new address, if they had no knowledge?
So,
this qualifies. The second statement
Mr.
qualifies the
Chakraborty,
first
only
one.
one thing. In 2017, your address was this, Round Tank Road. In 2017, your address was Round Tank Road.
Grand Tank Road, GT Road.
GT Road.
Round Tank Road. I did not. Round Tank Road.
I thought that my power has changed.
No, my.
Yes.
But 18 July 2020,
So,
husband died, I shifted.
All right. So, when did you inform this fact to the commission of your change?
Lord,
Because your admission is that you are staying there. When did you intimate the commission you are a party? When did you intimate the commission that you have changed your residence?
Lord, the claimant himself intimated the commission. Claimant intimated the commission. My
So
case
you
in
did not intimate.
my case in para 4. Lord, kindly read it for.
Have you intimated?
Lord,
yes or
let me read it. What I have made case I have made out. After demise of the husband, the appellant has been living with her daughter and son-in-law in the address mentioned herein above. And even though the fact was well known to the knowledge of the claimant respondent, no information or notice was ever sent to the appellant at her residence.
Chakraborty, I have read your case. My question to you is whether you have informed yes or no.
But perhaps not.
Should be
Perhaps not.
perhaps not.
Perhaps
Yes. Because they
Lord,
knew,
the
because
execution notice.
You knew that they knew.
Execution notice was sent into my new address. From there, I got the knowledge that there has been an order. And for 250 days delay, I would be suffering this prejudice when the proceeding itself has been filed after 16 years. When it is could not have been accepted. Kindly have a look at 24A.
Yes, yes.
Kindly have a look at 24A.
Don't take me to 24A because
So your
I'm
lordship
still now in 15. I cannot go to let me
Lord,
first
if
cross.
the proceeding itself is bad in law, your lordship will not look into that. Sitting in 227 jurisdiction. If the proceeding itself could not have been accepted by the tribunal.
Section 5. Section 5 is yet to be admitted.
And the non-maintainable proceeding order should be passed.
Did not succeed in two forums, Mr. Chakraborty, on this.
And the forum has not considered my case.
That you have made those points before the State Commission at the time of hearing of Section 5. Please show me those.
That the proceeding is not maintainable.
Yes.
Appeal to bar. Just give me a minute.
At the time when the order was passed.
Kindly give me.
Please show me page 69.
Just give me a minute.
From
Just give me a minute. Give me a minute. Appeal before NCDRC, revision petition before State Forum. Revision petition.
Not the petition, Mr. Chakraborty. I'm asking you from the order, please show me that you have raised this point before the State Commission on when the matter was heard on 7th of May 2024.
But points
we have
taken
taken
not
many points.
considered. Points taken not considered.
Please go there. Please go there, file an application, appropriate application. You have taken points, not considered.
Lord, if kindly consider, Lord, it was the duty of the district forum to not to accept the petition, Lord, when it is could not have been accepted.
Please don't expand the scope of this matter.
Lord, your lordship is exercising your lordship's not jurisdiction under 227. My lord may look into it, Lord, whether proceeding could have been initiated. It could not have been initiated after 16 years. Kindly consider that that point was taken in the written version, not dealt with even by one line.
Yes,
Now I said that 2 points I have taken, that husband was looking after the litigation. I was shifted to my daughter's place after his death. He engaged lawyers. I did not know the lawyers. So I could not, when I have received the notice, immediately I have taken steps. June, I received the notice. July, I filed the proceeding. I have produced medical reports in addition to that of 300 pages. Court has gone into the aspect that none of the medical reports says it is bedridden. But the document says from 2019, I was suffering. A lady of 76 years. No, 250 days delay. For that, I'll have to suffer.
Many persons more than 76 are regularly attending.
No, that I'm not praying for any sympathy on that. I'm not praying for any sympathy on that. But the court should have considered this. This is a sufficient cause that I have shown.
Factor is just a number, Mr. Chakravarti.
This is a sufficient cause that I have shown, and that's not been dealt with by the court.
Anything more?
If my lord is not willing to go into that aspect, not what else I can say.
Can I go into that aspect?
Lord, if the proceeding could not have been initiated, your lordship may go into that aspect.
Mr. Chakravarti, please show me either before the state commission when this application was heard, or before the national commission. You raised this point.
But kindly take the appeal. Kindly take the appeal before the state commission.
Mr. Chakravarti, you are confusing between the main appeal and the section 5. That's the problem.
My lord, when the section 5 application was being proceeded with, Lord, the tribunal also, Lord, what is coming from the court, tribunal was considering the delay aspect.
Yes.
The delay aspect. There was an appeal along with the section 5 application. This
appeal has to be considered, merits.
Chakravarti,
if you argue that, it's very difficult.
In the appeal, I have said that. Kindly come to page 413 once.
Yes. So, while section 5, deciding an application under section 5, the appeal is to be also heard.
No, I'm not saying that. But if the proceeding could not have been initiated, the state commission would not look into it. It was barred.
Mr. Chakravarti, do you have an authority in your support that if a proceeding is ex parte barred in section 5, that has to be looked into? Please show me that.
Lord,
Because that's the issue.
I would rely on Justice Dipankar Datta judgment. Justice Dipankar Datta judgment. I was going through a judgment rendered by Justice Dipankar Datta and Justice Bindal in a proceeding initiated from the administrative tribunal. My lord knows, my lord, in those specified acts, my lord, there is a time limit given, section 22, section 23.
Yes.
My lord, the court said that the tribunal did not have jurisdiction to accept the petition. Here, I say that the tribunal could not have.
Considering the delay aspect.
Lord, delay, no delay, kindly considers.
There is no quarrel to this proposition.
So your lordship will dismiss an application which has arisen out of a void petition or a non-maintainable petition. A petition which could not have been accepted at all.
Yes.
No, I don't want to, my lord. And for 250 days delay.
Mr. Chakravarti, length is not material. Length of the delay is not material.
How we have explained. That is material. We have explained that.
Please give me the judgment which you are relying upon.
Relevant paras. But this relevant paras is not rightly marked. I'll just show you. Just give me a minute.
You have marked it there.
Yes, just let me find out. Just give me a second.
That is the problem now. You are only marking it there.
This is reported in 2025 SCC Online, Supreme Court 916.
Paragraphs?
Just give me 1 second, Lord. Lord, kindly come to first paragraph 25. Lord, the limitations, the section 21 has been quoted. Paragraph 25, the section 21 has been quoted 1 year from the date. My lord, kindly see.
Yes, yes.
Then para 28, my lord, may have a look at.
Yes.
That was an exhausting the remedy. In 21, there are two parts. One is exhausting remedy, second is the time limit. Then kindly take para 35.
Yes.
We hold that except in cases where final orders are passed on the appeals, revisions, memorials, representations which are statutorily provided, limitations for the purpose of filing the original application under section 19 of the 1985 Act in view of the above referred decisions and section 21 and 20 thereof has to be reckoned keeping in the mind the date of accrual of the cause of action and the proximity of the date of representation and the period of 1 year for filing an application. Application has to be counted from the date of expiry of 6 months and such representation, if no order is passed, needless to observe that the cause of action cannot be deferred by making a highly belated representation, so and so. Then kindly take to para 36 and 37. On such premises explained above, the respondent should have, if she felt aggrieved by the action of the appellant granting her benefits in the financial upgradation MACP scheme instead of ACP scheme, avail the remedy before the tribunal immediately after her rights were affected. She ought not to have waited so long for ventilating the grievance, though a belated representation filing such belated application which was rejected in no time did not have the effect of postponing the cause of action. Then 37, both fora, that is the tribunal as well as the High Court, did not rule on the objection of maintainability of the way, despite such objection being sound. The reason that we have assigned would lead to the irresistible conclusion that the way was time-barred and should not have been entertained by the tribunal. I say that the district commission should not have entertained the proceeding. Kindly allow me to show that once. Kindly allow me to show that once, that when the cause of action and when it was filed. Kindly allow me to show that once. Kindly, my lord.
Yes.
Kindly take, my lord, the complaint at page 146.
146. Yes.
Lord, kindly see at the top. The date of filing, 19th August 2016. My lord, kindly got that? 146. Now, my lord, kindly take first paragraph 9. My lord, the agreement is of 20th December 2003. 20th December 2003 for sale.
Which paragraph?
Lord, that they have said in paragraph 3.
20th of October 2003.
Yes.
October or December?
December. I said December.
But please check up because paragraph 5, there is a stamp of the notary on that. I cannot read it correctly whether it's October or December.
Yes, October. Page 150, para 6, first sentence.
150 also it's there.
Para 6, first sentence. 20th October 2003. Third line.
150.
150, third line from the top. In the said agreement for sale.
Yes.
So, Lord, that's clear. Kindly come to para 9 now. That thereafter the complainants on various occasions verbally requested the opposite party to register the suit flat in their favor, but the opposite party deliberately and motivatedly with malafide intention avoided the same and turned a deaf ear to the request of the complaints on that account. Abruptly, and to the greater misfortune of the complainants, the opposite party on 14 June 2005 to the reason best known to her by a letter intimated the complainant that she was unable to register the car parking space in favor of the complainant. So the first refusal, 14 June 2005. which is part and parcel of the suit flat, and also ask the complainant to take back the amount paid by them for the said car parking space. Apropos to the said letter dated 14 June 2005, the opposite party verbally openly declared before the complainants that if the complainants are not ready to accept their proposal, then in that case the opposite party would not register the suit flat in their favor. But since the complainant had already taken loan from the ICICI Bank for the entire suit flat, which also included full consideration amount for the car parking space, as well as they needed a car parking space for only which reasons they had booked the suit flat, they clearly refused to dishonor the said agreement for sale and take back the amount paid by them for the car parking as per the agreement. Letter of the complainant, 20th June 2005. Apart thereto, on 23rd November 2005, the opposite party sent a letter to the complainant intimating them that the draft copy of the said conveyance in respect of the suit flat was ready against the complaint number 1. On 24th November 2005, replied by a reply letter dated opposite party sent the draft copy of the same immediately as they were ready and willing to sell as enthusiastic to complete the registration 7 days, against which opposite party fairly on 22nd February 2006 sent a letter along with the draft copy of the deed to the complainant requesting them to pay the balance amount for the car parking space of the suit flat, and only by doing so the car parking shall be registered. Not the last line of that paragraph, but the opposite party never cared to intimate the complainants in this regard to the said registration till 9th September 2011. My lord has got that. Para 9 last. Then 10. The time rolled away, and in the meantime, complainants on innumerable occasions sincerely attempted to contact the opposite party in regard to the said registration, but such attempts yield no fruitful result. Opposite party simply applied mean and diabetic delaying, harassing tactics. So and so, my lord may skip over. Kindly come to paragraph 11. That in the meanwhile, the opposite party and her husband started threatening the complainants to give up our right to the car parking space. And when the complainants did not abide by this, they starting threatening the complainants to reduce the car parking space from 150 to 100 square feet. To bear the threats, complainant was forced to lodge a GD entry on 21st June 2008 with Howrah police station. Then that very astoutly on 9th September 2011, the opposite party through her learned advocate sent a letter to the complainants to register the flat only barring the car parking space, against the complainant by themselves on 15th September 2011. Their learned advocate 23rd September 2000 denied. Then the next sentence, further on 29th October 2011, the opposite party by her advocate again asked the complainant for making payment of the balance amount, suit plot on fixed for registration within 7 days. My lord may now come to page 155 once. But to the utter surprise of the complainants, the opposite party again on 16 December 2011, again likewise the previous occasion, denied to register the deed of conveyance directly. Page 155 top. Instead, the opposite party once again insisted registering the said agreement for sale first. Once again, to avoid further delay harassment, complainant were compelled to register the said agreement on 19th April 2012. By making the payment of the stamp duty agreement for sale on 7th February 2012, though and intimated the same to the opposite party advocates letter 11th May 2012. Then my lord may take my lord paragraph 12, page 156. As such, being frustrated and fed up without seeing any light at the end of the tunnel, the complainants personally handed over the opposite party an affirmed deed on 21st June 2016. It must be mentioned that such draft of the deed were also given to her earlier very many occasions within the period from 2012 to 2016.
Yes.
Lord, my refusal to register the car parking first came in 2005, and I continued to maintain the stand till 2011 that I will not register the car parking space according to the claim case. And this was filed in 2016.
Yes.
And 24A says within 2 years it should have been filed. And this, if my lord sees my written version once,
Yes.
I have taken this point very categorically in page 163, para 4, and my lord, para 164, page 164, para 6. I have said that the cause of action of this case first arose admittedly on 20th October 2013. Therefore, the complaint is apparently barred by the laws of limitation.
Yes.
This has never been considered. In my humble submission, my lord, from the claim case, there is the cause of action arose on 2005, and according to them, since 2011, nothing has been done as per para 9 last sentence. And she filed the petition in 2016, much after the period of mentioned in 24A. 2 years. So the district forum could not have considered, could not have accepted the petition.
Yes.
In view of the judgment of the Supreme Court. So, my lord, if the initiation of the proceeding is bad, then, my lord, for
everything goes.
Everything should go. This is my humble submission, my lord. I give it to your lordship. And in paragraph number, paragraph number 11, last portion, he has made out a case that I have asked him to register the agreement in 2012. So from 2012 to 2016, 4 years time.
Yes.
No, no,
What is your ground for not transferring the car parking space?
The payment was not made, perhaps.
Where I was stated in the written version.
Just give me a second, my lord. Just give me a second. I'll just show you lordship from my written version. I will not see anything what is not mentioned
Give
there.
me 5 minutes time. In the meantime, you can search those paragraphs. 5 minutes time.
May I come back tomorrow morning? Just I'll take all the instruction and come back tomorrow morning. Lord, I have a matter fixed at 12. It's going on. It's fixed. Lord,
Right. You can done. Yes.
I don't want to disturb your lordships on that. Lord, kindly not embarrass me. I'm waiting, Lord. I'm waiting. Kindly come back. I cannot do that. Lord, I'm waiting. Yeah, But very quickly, I'll show only two page 156 of the complaint. 156 of the complaint, just come once.
156.
156. But kindly, I can't figure out the paragraph number. This has to be para 13. Para 13. Kindly see that the last date, last ditch effort, the complainant.
You are trying to specify last 4 sentences of that, last 4 lines of that paragraph.
Yes.
have marked that.
Fruitland, which was also due
Sir, I
for
have marked that.
Well,
Yes.
now kindly take my written version. Only 1 or 2 paragraphs. You also wanted to know.
Show me what is the positive case in the written
Yes. Kindly take that. That milord is at page 163. Just take it for once.
Yes. Except limitation, what's your positive case?
Para 2, complaint misconceived limitation. Para 3, para 4, barred by limitation. Para 5, para 6 and para 7 is my case.
No, written
Para 6
version.
and 7.
Which
Yes.
page? Which page?
163.
163. Paragraph 5 is complaint is not a consumer.
No, para 6, 164, para 6. Next page. Para 6
164
and 7 is my
yes.
positive case.
Yes.
That there is no involvement of the developer in the agreement for sale, as the owner agreed to sell the flat herself. However, although the alleged purchaser was put in possession of the self-contained flat, but the proposed purchaser did not pay the due in spite of repeated requests, but possessed the said flat without taking steps for registration of the flat, and thereafter the application before the forum, after a long gap or of decade, is clearly barred by time barred. Moreover, the cause of action of the case first arose on 20th October 2000. Thereafter, the complaint is apparently barred by limitation. Then para 7, that there is no concluded agreement for sale of car parking, nor any consideration paid therefrom, and accordingly, question of transfer of the car parking cannot and does not arise. This core
agreement for sale.
আছে এখানে পেজটা বলতে একটু আমাকে 464
464
এটাই তো
Second schedule, my lord, your lordship will find 474. Second schedule is the schedule, my lord, which is proposed to be transferred.
এটাই তো নাকি হ্যাঁ
474 it starts.
So Chakraborty, please check out whether that is the agreement or not.
They cannot.
20th October 2003, page 465 says. তুই একবার দেখে নে তন্ময়
Regarding car, দাদা আমি দেখে নিবো। And
এটাই
regarding
তো
the car parking, your lordship will
Where is
find
the
that
schedule?
page
Extra-
474, the second schedule starts. It's described both below the self-contained flat and at page 470.
Second schedule is the disputed
Yes,
property.
my lord. That's the property proposed to be transferred. And 475, your lordship will find regarding the car parking space. Because the first portion is delineated and butted bounded, that's the self-contained flat. And the second portion is, my lord, the covered garage space.
এটা ওদের ডকুমেন্ট আমাদের document বার করো সেটা কোনটা কোনটা কোথায় পেজ বল ইজ দিস দ্য এগ্রিমেন্ট কোন এগ্রিমেন্ট থাকলে বার করো
Lord, Mr. Chakraborty, on a lighter note, don't take it seriously. In 2003, ambassador car was flying. 2003.
yes.
New ambassador
Yes.
cars were.
I think
2008
2008 I am not
Other
sure.
cars have also come. So the car parking space says ambassador car for keeping an ambassador car. Don't take it seriously.
No.
Yes, now you can proceed. Yes.
দেখ ওটা দেখাও Lord, kindly just have a look at
So this is the agreement.
Lord, kindly look at the second schedule one more time.
Yes.
The first schedule talks about the entire building. Second schedule kindly sees, my lord. I very seldom your lordship gets to see. Second schedule talks about the flat first, then the Chauhoti, the area. Then this portion is there, all that cover, uncovered car, scooter parking space for parking of car, one of car not bigger in size, that the Indian made ambassador car exact location be fixed and marked out of the sole discretion of the developer or before delivery or possession of the said unit flat. Lord, I am not sure. I cannot comment on this. I should not comment on this. But just give me a second. I think there is nothing indicated in the agreement about the car parking anywhere.
This is the agreement. Is it not that agreement?
Okay. Yes. It's already mentioned in the schedule about the car parking space. It is the agreement. But that's a case that payment was not made, and that's the difference.
Payment was not made for
the car. Can you see again? Come back to the written version. Paragraph 6 and 7. Developer agree that there is no involvement of the developer in the agreement for sale. The owner agreed to sell the first flat on behalf of, however, alleged purchaser or put into possession self-contained flat, but proposed purchaser did not pay the dues in spite of repeated request, but proposed that the said flat without taking the steps for registration of the flat. Then 7, there is no concluded agreement for sale of car parking, nor any consideration paid therefrom, and accordingly the question of transfer of car parking cannot arise. Now kindly see
yes.
The consideration portion. Total amount 8,10,000, 1,51,000 installments as follows. Then 20.
How much amount has been paid?
No, that is not the, it's not coming out of the defense note. I should not say that note. I have to sit with the client. It's not mentioned here. It says that the payment, but the claim case also says that the claim case, my lord, if my lord comes to that, the
Payment
claim
not made.
No, the claim case. Kindly allow me to show only one portion what they have said.
Yes.
Paragraph 9.
Yes.
Abruptly and the greater misfortune of the complainant, the opposite party on 14 June 2005 to the reason best known to her by a letter intimated the complainant that she was unable to register the car parking space in favor of the complainant, which is the part and parcel of the suit flat, and also asked the complainant to take back the amount paid by them for the said car parking space. Apropos to the said letter, opposite party openly declared before the complainant that if the complainants are not ready to accept the proposal, then the next para, they clearly refuse to dishonor the agreement. Then kindly come to the next paragraph 11. They have said that I have asked for money for the car parking. Yes, page 152. Along with the draft copy of the deed car parking space, then এটা বার কর যেখানে বলেছি যে আমি টাকা চেয়েছি। Yes, page 153, last portion. Further, on 29th October 2011, the opposite party by a learned advocate asked the complainant for making the payment of the balance amount of the said flat on the date fixed for registration within 7 days from receipt of the same so and so. So my two cases that car parking was never agreed upon, payment was not made. That's the case, and it was time barred. Now, right now, how much payment was made, it's very difficult for me to apprise your lordships, my lord. I have to take instruction on that. I should not
Anything
comment on
more?
that.
Any,
No, my lord, no, no. This is what I have.
yes. Any other decision you want to cite
No, no.
on section 5?
No, that meritorious matter should not be dismissed. I was carrying, but there are contrary view also. But
Please cite both, because now the Supreme Court has said
it's my duty to cite both.
against you also.
Yes.
So please take the trouble of citing both.
Against me, I'm telling your lordships. Just give me a second. It's in my iPad also. নাহলে আবার বলে দেবো উকিলের দোষ নাহলে বলবো
Frequently, my lord, we are doing that, because the contrary view also have to say.
just give me a minute.
Yes, you can search out. Yes, Mr. Mukherjee, you start.
Though, my lord, I am not, my lord, in my respectful submission is not answerable with regard to merit of my case. But since, my lord, my learned senior friend has shown that it's an open and shut case on the ground of limitation, perhaps it's not. Why? Because he started from 2003, missed out that this agreement itself is being registered subsequently in 2012. This is an agreement for sale which was executed in 2003. Beloved, the agreement contents, beloved, I shall show Article 54, I am aware. Agreement contents, beloved, no time limit with regard to its execution. Sorry, beloved, registration. No time limit. Rather, certain contingencies has been given to the developer to complete it within a certain period of time. But with regard to the ultimate registration, no time limit prescribed. So the Article 54 says when I actually realized the refusal on the part of the other side. Now what happened? In 2003, agreement executed. Times and again, my lord, I am also an 80 years old, my lord, litigant. Times and again, my lord, the discussion starts.
80.
Yes.
76 versus 80.
Only one thing, we are ready to register the flat. We are ready to, that's the instruction I have received, ready to register the flat.
They are like
Car parking, we have
from 2016.
if he wants to use a car parking in the building, we have not sold any car parking. We can later use it, but we can't sell it. That's the instruction, my lord. Good, bad, indifferent. That's the.
He's allowing, my lord, outsider, my lord,
No,
by
he is
taking rent.
He is
My lord,
also.
their car to be parked, my lord, rather, my lord,
They are
I
also
am
parking.
entitled as per agreement.
Flat, Mr. Mukherjee, they are
I'm
ready
ready.
to register.
I'm ready.
Now,
He's possessing. I'm ready today. Today only I'm ready.
But my lord, this my lord, person is fighting from my lord, last 1 decade only because of this. Because
then you could not register your flat, Mr. Mukherjee.
No, my lord,
That to engage you for registration.
Registration, my lord,
the flat.
Yes.
Till now, it has not been registered. So now Mr. Chakravarti is saying it will be registered.
But on the no, no, my lord, but my lord, what Mr. Chakraborty is suggesting, I will have to give up my right with regard to the car parking. There lies the dispute, my lord. Why, my lord, may I just?
Is it your condition?
Yes,
That is what.
So, Mr. Chakravarti, is it your condition or unconditionally you will
Then
register that? Please make up your mind. Whether it's conditional or unconditional.
কথা বলতে হবে। I need to speak with the client once, at least once. I thought it would be settled. Why my learned advocate on record did not get time to sit with them, I don't know. I have admonished him that it fell from the court.
On
Should have
merits,
done it.
Mr. Chakraborty
But
has
I have
done
to
it.
take
But I do
instruction.
not think, my lord, it will happen because for last 10 years it has not been done.
Yes.
2012, my lord, after long persuasion, I being able to, my lord,
It was registered in 2012.
2012,
Please show me that.
Yes, I pleaded, my
Sorry,
lord,
page 155. I've shown that.
my lord, paragraph 11 is a longish paragraph, my lord, of my, my lord, statement of claim.
Yes.
Paragraph 11, last part your lordship will get, my lord, it was registered in 2012. This was, my lord, auto with volume থেকে দেখাচ্ছিলাম না জজ সাহেবকে আরেকটা বের করে রাখ
7/2/2012.
Yes.
Page 155, first paragraph, second last line. Yes, I have marked that.
Now, so, my lord, so far as regards Mr. Chakraborty's submission till 2011, the causes of action has been arised. It's not that. And my lord, kindly to accept now paragraph 14 of my lord claim.
Yes.
But your lordship knows it's a bundle of cause of action. So whatever happened in 2003, 2005,
By 2016, lastly he refused.
yes, and Article 54 kindly takes up now, my lord, the agreement. Agreement, my lord, does the contingency, but kindly takes up, my lord, there is no time limit in my respectful subcode. এখানে তো এগ্রিমেন্টটা না না জজ সাহেবকে এখান থেকে দেখাতে হবে এগ্রিমেন্টটা বের করে দেবো। Yes.
Milord, kindly takes up, Milord, the last part of the agreement. Yes, at page 475. I'm sorry, Milord. At page 474, top. 474, top. It's my duty, Milord, to point out, because Article 54 says, Milord, something. 474, Dada. Internal page 35 of the agreement.
Yes.
Purchaser shall neither be entitled to claim any compensation from the owner, nor shall be entitled to cancel the agreement for demand or refund of any amount, subject to the provision contained in the proceeding clause. The owner shall make ready the said unit in decent and habitable manner within 14 months from the within 12 months from the date hereof, and shall also complete and install the common portion of service within a period of 18 months thereafter. So, Milord, regarding the balance consideration amount payment or regarding the registration, no time limit prescribed under the agreement. So, I am at the second part of Article 54. I am at the second part of the Article 54. Now, Milord, I am coming. Mr. Chakraborty has said that it's such a meritorious case on limitation. That's why, Milord, anything and everything what has been stated in the application under Section 5, that should be allowed. In my respectful submission, paragraph 6 of the Section 5 application itself demonstrate that no court shall exercise, Milord, any discretionary jurisdiction on such a frivolous, Milord, pleadings made therein. Kindly takes up their Section 5 application once. 137. Section 5. I have shown before your lordship that the lady herself has affirmed the written version, affidavit portion also, address also I have shown before your lordship. 163. One, no, no, written version no. Written version to দর্শককে দেখিয়ে দিচ্ছি সেকশন 5টা দেখান এই সেকশন 5টা কত পেজে না 439. Yes, it starts from 431. So, Milord, in 2016, so 2017, that lady has affirmed the affidavit. Her address is given. Kindly now takes up, Milord, page 434, paragraph 6. The applicant was not aware. The appellant was not aware of paragraph 6, Milord, at page 434. It's section 5 application pleading.
Yes.
The appellant was not aware of any such litigation or orders passed therein, as her late husband used to conduct the same after coordinating with the lawyer, etc. However, the appellant doesn't even have the contact details of the learned advocate. 2020 husband died. The final award was passed in 2022. So for 2 years, the litigation proceeded. It's not an ex parte award. It's on contest. So the appellant consciously, after having affirming an affidavit in the year 2017, in paragraph 6,
show me the order of the district forum.
Yes, Milord, yes. Kindly takes up page 138. Final order, Milord, of the district forum. My lord would get, Milord, the operating portion at page 144. On evidence, the FORA has found that entire consideration amount paid, and their, Milord, frivolous plea in the written version with regard to that no mentioning of car parking, that has also been fructified, Milord, by the schedule, second schedule appended to the registered agreement for sale. Yes, it was done in contest. So, Milord, the frivolous plea with regard to that has been disbelieved by both the forum and, Milord, National Commission also, Milord, taken into consideration. Milord, if your lordship takes up the order impugned,
Yes, National Commission.
Takes up Milord, the order impugned. I will place only two portion of the order. Page 30, if your lordship kindly comes.
Page
30, Milord, 30.
No, no, please give me the internal page number of that.
Of the No, Milord, I am placing Milord the National Consumer Forum, sir.
Yes, internal page number of that.
Internal page ache naki number?
Because the certified copy, I am having the certified copy.
Milord, sorry, Milord, I am giving.
The
Milord, the
internal
second
page
page,
number at the
Milord, the second page of the order, bottom.
Yes.
The main question of consideration is whether the facts and circumstances of the case, the State Commission was justified in deciding the condonation of delay in filing the appeal and dismiss it as barred by limitation. We have carefully gone through the order of the State Commission, other relevant records and contention of the petitioner hearing. We have also considered the reasons for delay as contained in the condonation of delay application filed by the petitioner hearing before the State Commission in light of the observation of the Honorable Supreme Court in his commission in various cases. Milord, now, Milord, the cases is being quoted.
Yes.
I am not. Kindly takes up, Milord, the next page, paragraph 5.
Yes.
One portion I will read. Milord, in such and such, while considering the appeal filed against an order of the High Court condoning the delay, observe that condonation of delay being a discretionary power available to courts, exercise of discretion must necessarily depend upon the sufficiency of the cause shown and the degree of acceptability of explanation. The length of delay being immaterial, each case of the condonation of delay based on the exercise or absence of sufficient cause. I'm not pausing here for a moment. The court is conscious. He is not now kindly takes up the next page, not paragraph 7. This is primarily the observation.
Yes.
Primarily, it is the satisfaction of the fora considering the application for condonation of delay about the sufficiency of the cause, and we cannot substitute our satisfaction unless it is shown that the fora below improperly exercised its discretion to consider the application for delay based on untenable, arbitrary or perverse ground, and or its order suffers from any illegality or material irregularity. It has been held by the Honorable Supreme Court in Catena of decisions that revisional jurisdiction of the National Commission is extremely limited. It should be exercised only in a cases of contemplated within the parameters specified in the provision. That is when the State Commission has exercised jurisdiction not vested in it by law or had failed to exercise jurisdiction so vested, or had acted in exercise of its jurisdiction so vested, or had acted in the exercise of its jurisdiction illegally or with material irregularity. It is only when such findings are found to be against the provision of law or against the pleading or evidence, or are found to be wholly perverse, the case of interference may call for at the second appellate revisional jurisdiction. In my respectful submission, Milord, what the forum has said, it's the law, because Milord, today this can be a satisfactory explanation for your lordship. Maybe. I'm just giving an hypothetical example. But it may not be before the court will. So there can be two findings. There can be two findings, but until and unless one is perverse, the exercise of revisional jurisdiction, very rarely, your lordship knows, today, your lordship can say there can be a different finding.
Mr. Mukherjee, then there would not be so many motions, civil division application.
No, I am not saying, Milord.
Perversity. If
Yes,
you
I am
stick on those, there
yes,
should not be so many.
I am there. If it is not perverse, I have shown before your lordship the paragraph 6 and the Milord's consistent stand of the Milord petitioner before your lordship. If that be so, if it is not perverse exercise of the jurisdiction by the State Commission.
Perversity, Mr. Mukherjee, only one thing. In the application for condonation of delay, there were two grounds taken. One is illness and the death of the husband. That's one point. Other part is with regard to that she was not aware of those, and she came to know on a particular date. Thereafter, she took. Show me the findings of both the commissions on that aspect.
Milord, I will suggest, Milord, rather, if the first gate is not open, Milord, the person is explaining what? That look,
I'm first asking you whether there is a finding on those grounds, yes or no.
No, Milord, the court said it's not satisfactory. The court said it's not satisfactory. Why? Why, Milord? I am explaining. Why? Because the person is saying, they look, from June, I came to know. Why? How? He has explained. And thereafter, from June to this is the ground of delay because of my illness. But if the court found that the explanation of knowledge itself is bad, which I have demonstrated,
Where is
but
that
the
finding?
court said it's not satisfactory. My lord, I say if it is not perverse, if your lordship, because the court said also, upon detailed analyzation of whatever explanation documents that has been gone into, and the court has found that. And if it is
Anything
found,
more? Any judgment you want to cite?
No. For this, my lord, if the second view can be possible, that cannot be a ground for interference under Article 227. Before your lordship, my lord, I will not cite, my lord, any judgment, because this is the.
Yes, what do you say? Want to come back with instructions?
My lord, in that event, my lord, kindly keeps it tomorrow, my lord, will come back with instructions.
Tomorrow? Or you take 2 days more, I'm keeping it on Tuesday. Think over the matter. Conditional, unconditional, all.
Kindly keeps it
Only
in
one
next
thing,
week, my lord.
only one thing, please feel free to call Mr. Mukherjee or his learned advocate on record. Whatever is your suggestion, yes or no? Whatever is your suggestion, conditional, unconditional, and if there is an agreement, you can.
So far as the hearing is concerned, my lord, that is
Hard. Agreeable, it's one way. If you are not agreeable, then no further hearing concluded.
My lord.
Grateful. Yes, call the next matter. Yes, 27. 27 দুটো সময় আছে। Next.
Lordship, I beg to appear for the petitioner. I'm being led by Mr. Kormokar. He's on his legs. If you would kindly grant me short passover.
Passover next.
Lord,
Yes.
Your Lordship,
Opposite party, my lord.
I also appear for the petitioner.
Yes.
Mr. Kormokar is leading me.
Very short matter.
Yes, what is this matter? Yes.
My lord would kindly see their impugned order. My lord, the impugned application that is at page number 74. But I'm not going into the merits. It's a very short matter. It's on the point of maintainability.
Yes, yes.
My lord, page number 74. My lord, this matrimonial suit number reference has your.
74, yes.
My lord, the reference matrimonial suit number 2572 of 2023. My lord, this is an application of restitution of conjugal rights filed by the petitioner. Now, my lord, this application, this impugned application, my lord, will see the prayer part 76. Page number 76, the prayer part. My lord, it is of shifting of custody of minor children to their father. Now, my lord, the petitioner husband has already filed an application under section 25 of Guardians and Wards Act. And thereafter, my lord, they have filed this application in the restitution of conjugal rights application.
Yes.
My lord, this is not maintained. Kindly sees the impugned order what the learned trial court has held. My lord would find it in the certified copy, my lord. Order dated 8/6/2026. My lord, may I place it?
No, no.
ওদের জন্য করি। ওদের জন্য করি। ও আচ্ছা, হ্যাঁ, সেটা।
Since, my lord, they have already filed an application before.
Yes, Mr. Kormakar.
No, that is, my lord, I'll say, my lord, that is, first of all, I don't think that's their best point. That because I filed section 12, that's why I won't have any right to press this. Lord, presently I will be pressing this. Lord, this will obviously have an implication on section 12. Lord, I will take that risk. The reason is, Lord, kindly takes note of this list of dates. হ্যাঁ, নিশ্চয়ই। 2014, Lord, the marriage was solemnized. Need not look into this. 2023, I had instituted this proceeding under, Lord, section 22.
Now, Mr. Kormakar, what is the age of the
Lord,
child?
one is 7, one is 9.
7 and 9.
My lord.
Son or daughter?
Both sons.
Both sons. Now, the visitation is going on.
Visitation is going on. It was stopped by virtue of contempt order. Now it is going.
Now it has normalized. Now, what is your grievance with regard
Your
to
lordship would
custody?
recall this matter. Lord, I came up first time before this honorable court, before your lordship. Lord, I had raised a point of shared parenting. Your lordship wanted me, Lord, to go back and address the court on shared parenting. Lord, I made that application. That is section 12. That application I have filed in the month of June. Lord, for some reason or the other, Lord, my application till date has not been heard. Now, Lord, this application has been heard out. Lord, here also I wanted the same remedy. Lord, the same arguments were
Only
forwarded.
one thing. Now, for the purpose of shifting the custody from one parent to the other.
But now I am
several-
not asking for an entire shifting of the custody. Lord, I am
What do you
asking,
want now?
Lord, I am asking for a temporary shift of custody for at least a day, so that I also have a family. Lord, they are my sons also.
What is the present arrangement for visitation?
Arrangement is 2 hours twice a month in lawyer's chamber, which the guidelines also prohibit. Which the guidelines of this honorable court also prohibit. Lord, Supreme Court judgments are there, the guidelines also prohibit in lawyer's chamber. Now, what is being done is, Lord, the children are taken to private psychologists, at whose instance I do not know. And Lord, the reports, those are furnished. Lord, I have obtained those reports from the affidavit, Lord, filed in the contempt proceeding. There it has been projected, the children only go to the psychologist after meeting the father for twice a month for 2 hours in presence of the 2 advocates. Lord, the father teaches only ill things about mother. This is what the psychologist is doing. Lord, this kind of psychologist should be immediately taken to task. Lord, this is the manner in which, Lord, slowly poison is being, Lord, infiltrated in the mind of, Lord, these 2 young souls. I am a father, Lord, I am taking all care of them. I have my parents also. Lord, your lordship has held, Lord, that sons, Lord, children are, Lord, should be there with the grandparents. Your lordship has held, Lord, I am carrying that judgment. The Supreme Court has also laid down how, Lord, the psychologist would be appointed. Prior to that, our guidelines say, Lord, that prior to that, the parents also have to go to for the counseling sitting. Only then the child can be referred to psychologist. Lord, now everything given a go by at their whims and fancy, and at certain point of time, they come to court and say that I am not able to Lord, participate because the child is going for counseling. When the police go, they say the same thing, and they do not attend the court proceedings in section 12. This is their conduct.
But my
And
lord,
today they are saying, my lord, that section 12 is being heard out. So please.
Madam, please take instructions whether you are agreeable to send the child for some days to the father or for some hours in a day to the father, not in the advocate's chamber.
My lord, presently the issue, right, at present, my lord.
I'm asking you, please don't
Oh,
fight,
my-
ego fight. Yes, let that carry on, no problem. But after all, he is also the father. You are the mother, he is also the father. So the father is also entitled to have the company of the children. So if you are having 7 days uninterrupted company of the child, can you not spare 2 hours of exclusive to the father.
My lord, I would humbly submit, my lord. My lord, whether at all there this application in the main case, that is the restitution of
Madam, if you argue on law, I will consider that. I'm asking you,
my lord, I'll take instructions.
please take instructions and come back, because in the lawyer's chamber, it's difficult. Because let the father have some company with the children. After that, it can proceed stage by stage. It might not be that in one fine morning they are taking for 2 days or 1 day. But first, not from the may not be in the lawyer's chamber. If you agree, both of you agree, maybe for certain period. How far are your residences?
No, just not even 2 kilometers. No, they are in Lake Town. I'm in Salt Lake AA block.
It can be done.
My lord,
Some,
I'll take instructions, my
Please take.
My-
They are starting.
My lord, if I be permitted for a while, I am on behalf of the mother, along
Yes.
with Madam Priyanka Sarkar.
Yes.
Basically, I am dealing with the matters regarding the Barasat custody matters and the matrimonial suit in the district Barasat court, Your Honor, my lord.
Yes.
Now, the thing is, my lord, we don't have any objection. We don't want to put ourselves as an embargo regarding the normal and natural visitation by and between the estranged parent and the minor. That is not an issue, my lord. But the thing is, as my learned adversary is emphasizing upon the intention of the mother, I am also trying to put some emphasis upon the regular conduct of the father, my lord. That is our contention is, if the father is willing to meet with the minor sons daily, then obviously it's a great welcome to him. He can every day can meet with the minor sons at the residence of the opposite party, that is the mother.
All right, alternate day.
Alternate day.
One day he will go to your residence. The other day he will take him to his
But the
residence.
thing is,
So
my lord,
alternative, I think both of you can agree to that.
absolutely, my
Yes,
lord.
very fine
And
suggestion.
and one more thing, my lord, just
Please
a
give
few
suitable time.
seconds.
One day he will go to your house, meet with the child. Next day he will take. The father will take.
Certainly, my lord.
Only
Certainly.
one suggest time, day.
Only one thing.
Because my
498
chamber is in
was-
Barasat. It's a lot of time. Almost 3 hours for their conveyance charges. It's lot of time, my
Yes,
lord.
yes.
But 498
You will also not be disturbed from your professional.
Certainly, Your
Yes,
Honor.
yes. So let them
My
sort
lord.
out. That's better. Yes.
Allows me to come back, my lord. With
Both
the
of you
suggestion,
come back.
Lord,
When can you come back? Please
Monday.
take instructions.
On Monday we'll come back.
Monday monthly list. If you are
Not
welcome
Tuesday.
on
Not
that
keeps
day.
it Tuesday. Keeps it Tuesday. I'm sorry. Keeps it Tuesday.
List is.
Lord, at the cost of Lord being admonished.
এই বলছি যে এটা
The cost of being admonished, my lord.
শ্রীজীব চক্রবর্তীর বই বইটাকে ওইখানে না
Of being admonished, my lord. Item number 28, my lord. I was, my lord. My fault, my lord. Should have been here, my lord. My lord, it has.
I am telling to take up the matter because the engineer is with before your lordship with the original record.
Yes. Call the next matter. Next.
We were here, my lord.
Please wait, Mr. Mukherjee. Yes.
After two, there is a
What happened?
Mr. Deepak Sengupta expired. Therefore,
the two no.
I appear on behalf of the petition.
Two. All right. Please wait. Come at 1:40. That is the concrete instructions, Mr. Mukherjee, from 2 p.m.
We are the member of the part. There is a meeting, my lord, at 1:25.
Call the next matter.
1:40. 1:40. 140.
140, yes. 2 p.m. from after 2 you have said nothing will be done.
No, there may be a resolution. We can't say anything.
Yes,
How can we say, Milord?
Yes, yes, yes.
We are the member. You will.
Both of you are here. Yes, where is the next matter?
Your Lordship, this matter was taken up by Your Lordship yesterday.
Yes.
My application under Order 26, Rule 1 for
Lordship
commission.
required me to seek instructions. Your
Yes,
Lordship
yes,
wanted
yes.
the 85-year-old lady, the
Osteoarthritis she is suffering from.
Lord, I have taken instructions from my client. My submissions may be a little unpalatable, but I have to make them. Milord, we seriously dispute this doctor's certificate. Today, Milord, the only prayer that I am making is that if there is a pathological center of repute such as Quadra, where imaging is done, and it is proved that this person, we are not disputing, Lord, that she may have osteoarthritis. We are disputing the severity of it, that it is so severe that she cannot travel by car from Damdam to Alipur. Lord, the only prayer that is being made is at my cost. If an institute such as Quadra,
I appreciate that. That also can be done, but that will only delay the proceedings. You want expeditious hearing of this
Lordship,
proceedings. For that, what is the problem if on one day this commission is made?
The
without going into that, without even if I don't dispute your submission that it's not that severe, she can move. After all, you are not disputing the nature of the illness. Maybe the severity severity you are disputing, and the age is also a factor. So one day it can be fixed, that can be done on that day. Otherwise, he will go procure that. You may file objections. You may say yes, another doctor. So this will only delay these proceedings. For that only I am asking you.
Milord will kindly bear with me for a minute. Thereafter, whatever falls from your Lordship, I will obey, Milord. Milord, the sole purpose for this affidavit that was filed is to delay the proceedings because I filed my.
I will not allow that. I will not allow that because I will fix a date from here. Has to be done on that date.
Lordship, kindly.
I filed the plaint, Milord, after a year. Written statement was filed. After 3 years, suddenly a letter came from one Mrs. Reena Shandal, who appears to be my mommy.
I understand that is what I am. That is why I am asking you. I will fix that time. Otherwise, what suggestion you are giving, I am not against that. But that will further delay your proceedings. That's up to you.
We take that risk. On instructions, Milord, and again, leave it to your Lordship. On instructions, Milord, we would like to take that risk of delaying rather than her just not coming to court. Your Lordship may kindly permit me to file a short affidavit because whatever I am saying, it need not fall from me, Milord, and I am not somebody who can dispute, Milord, a doctor's certificate. But your Lordship will kindly see.
They have used an objection to their my application.
Not an objection, but to bring certain facts on record. But because it needed to be said on oath.
No, you cannot say anything new. You have to rely on your written objection. What is your written objection to this?
They have filed their objection.
No, Milord, yesterday the matter was taken up. Your Lordship wanted client instructions.
Yes, yes.
I am only submitting this affidavit, Milord, because the client has to swear on oath as to what she knows.
I did not ask
Because this is a because yes, Milord.
But please show me from the written objection what is your objection.
I'm like a written objection file comes. Milord would
You have filed any written objection.
Yes,
where is that?
Yes, yes.
Yes, Mr. Chatterjee, where is
Page
that?
63, your Lordship will find. With regard to 26(1), it starts at page 63.
No, with regard to the illness, which paragraph?
From page 64, your Lordship can find from paragraph 4. That is the first paragraph at page 64. They have stated several things.
Which paragraph deals with this illness?
They say that paragraph 4 also, your Lordship will find that the fact is that Reena Shandal, even though is an aged lady, but is very much fit to travel to this court for adducing her evidence.
I am grateful to my learned friend. Paragraph 4.
An open court since
what I
in
said in my
reality she has been
affidavit here
visiting
also.
the defendant number 1 and homes of other relatives with defendant number 1.
This is what I have said before, your Lordship.
Mr. Chatterjee, have you disputed this fact?
In reply, there is no reply to that, but I have.
This is a statement. This is a positive statement.
But the medical certificate has not been challenged. There is a medical certificate to order 20. With regard to your lordship,
show me the medical certificate.
Yes, page 57, your lordship kindly sees. And also your lordship will see the provision of order 26 with regard to commission. It clearly says that she is unable to move anywhere for any purpose.
This is as blanket as it gets, Milord, which is why I'm disputing this.
What more
As
in a
blanket
medical
as
certificate? What is
Strategy,
And your lordship will kindly take up, if my learned friend says that the medical certificate is to be challenged, your lordship kindly sees order 26 rule 1, the explanation.
Milord, I do not understand the hesitation of my learned friend to subject
not
Mrs. Shannal
it is
to a
not
diagnostic
me.
inquiry. I do not understand the
never-
hesitation. Milord, I will not stand in the way if it is proved on diagnostic inquiry that she is actually unable to travel. I will withdraw any objection, Milord.
Lordship kindly
I do not
sees with
understand
regard to
that
medical certificate, your lordship
the
kindly
Chatterjee
sees.
must be having some medical documents in support of this certificate. She is regularly having treatment.
Your lordship, that was not produced, so I have not annexed that.
You have those?
I can bring before your lordship.
Please bring those, because what is the basis?
Your lordship will
some tests.
One thing I shall.
Tests undertaken.
Your lordship,
because
I will.
She's regularly being treated by that doctor. So the doctor must be having something.
Absolutely.
Please bring those.
Your lordship,
because,
I have annexed a section 151 application. I'll be very candid to your lordship. An application was filed for recalling of this impugned order. I have stated in this revision, I have annexed that application along with the medical documents, further medical documents. But in my revisional application, I have admitted that I'll be undertaking not to place this before the trial court, since I have challenged it before this honorable court. So I have not placed these documents before your lordship. Now, those are annexed at page 8.
You wanted to, you have filed 151 with those documents.
Yes, there are 3 documents, your lordship.
So I can permit you to move that application before that court.
Since I have come up before your lordship, that is why I have undertaken not to praise that. I have undertaken.
Dismissed as not praised.
No, probably not. I do not
here
in the
I
revisional
allow you to
application.
move there. Let produce all documents. Let the trial court consider that.
Then your lordship kindly grants me liberty to produce any additional document to this, whatever I have. I have already supplied 3 documents. If I have anything by a way of supplementary.
Which paragraph you have stated?
Yes, in the revisional application, I will just indicate. Paragraph number 12, page 5.
Paragraph 11 you have said. Where is that? Annexure F, which page?
That is page 80 is the documents. The application starts at page 70. That is 72. The application starts.
This application under Article 227 of the Constitution of India is at the instance of the first defendant and being aggrieved by the order dated April 30, 2026, passed by the Learned Additional District Judge 10th Court at Alipur in OS number 3 of 2022. Full stop. By the order impugned, the application under Order 26, Rule 1 of the Code of Civil Procedure stood dismissed. Full stop. Mr. Chatterjee, learned advocate appearing for the petitioner, submits that after the impugned order was passed, the petitioner has filed an application under Section 151 of the Code of Civil Procedure, annexing certain medical documents in support of the medical condition of the
witness DW proposed DW2.
What is her name? Mrs. Reena Shannal. Full stop. He submits that subsequent thereto, the petitioner has decided to challenge the Please let me know.
Lordship, very well. Lordship, please. Wait.
Who is appearing? You are for the petitioner? Where is the PP? Passover. Can you bring him at 2? Yes, Passover next.
My lord, from 2 p.m. my lord, as well as
Taken on the prayer of the learned advocate for the petitioner, list this matter tomorrow.
on the program.
I am for the petitioner.
Yes.
I am appearing for the opposite party, my lord.
Yes. Yes.
My lord, I am the defendant, my lord, in a suit, my lord, filed for, my lord, recovery of khas possession, my lord. This suit is under the, my lord, provisions of Transfer of Property Act, my lord.
You are the plaintiff.
I am
the defendant, my lord, in the suit, my lord, filed for eviction and recovery of khas possession, my lord. The suit was, my lord, under the provisions of Transfer of Property Act, my lord. My lord, there was a suit prior to this, my lord, filed by me, claiming, my lord, declaration of tenancy. Now, my lord, in the subsequent suit filed for eviction, my lord, I filed an application under section 151, my lord, praying for, my lord, a stay of further proceedings of the eviction suit till disposal of the declaration of tenancy suit, my lord. That has been discarded.
Want your tenancy right to be declared?
And my suit
Yes.
is for under 2G, my lord.
2G.
2G, my lord.
Everything your plaint in that suit will be your written statement in this suit.
That is there.
And subsequent, my suit
Kindly
is
see, once the order impugned, my lord, the court has, my lord, mechanically, my lord, rejected this application, my lord. But only saying that the issues has to be same. It's the court has
rightly,
but my application was under section 151, and my contention before my lord is, my lord, if the issues are dependent, my lord, on the issue, my lord.
When you have filed your suit?
My suit is of, my lord,
2019.
2019.
both are
both are
both
2019.
are 29.
What are the stages of both the suits?
Lord, the first suit, my lord, it's yet to enter into trial, my lord. Issues.
And my suit
Issues are framed
already, I
on, my
have
lord.
tendered my chief, PW1 already tendered my chief.
Evidence.
Yesterday was the date fixed. They have prayed for time
Yes,
pending this application. They have to cross.
So, in your written statement, you have raised the plea of tenancy.
That is there,
You
my lord.
succeed in that.
But the court cannot pass a declaration, my lord, in their suit, my lord, in my favor. That court kindly considers that.
If
Court
my
cannot
suit
pass a
fails, their
declaration in
suit-
my.
Get that suit expedited. Your suit.
Right.
And
I will do so, my lord. That kindly considers once the order issued, my lord. And there is no reason, my lord.
I will supply the.
I that is why I was not putting this point, my lord.
This application under Article 227 of the Constitution of India is at the instance Please wait.
I'm for the petitioner, my judgment.
Yes, yes, Mr. Mukherjee, please come. Yes, I've considered the judgment of the Honorable Supreme Court.
No.
In Bishan Singh, that's the main judgment which you have relied upon, saying that the parties can, by legitimate methods, can
defeat
the preemption, a right of preemption. So I've considered that. Then I've considered the provisions of the West Bengal Land Reforms Act. This court therefore holds that the vendor and vendee cannot avoid right of accrual of the right of preemption under the West Bengal Land Reforms Act, unlike the general law of preemption, because I've given reasons. 9(2), there is no perimeteria provisions in that Punjab Preemption Act. With regard to those, I've considered the three decisions of the three coordinate bench decisions which were against you, and one decision which were in your favor. I've dealt with those four decisions, and the other decisions on that preemption is a weak right. Thereafter, the effect of the compromise decree, that was also considered. What is the effect of that in view of, and also the issue of sub silentio. That also I've considered that your argument was that each transfer from the subsequent, it will give rise to a fresh cause of action for a fresh Section 8. The original perishes, that also I have considered. Though the reasons assigned by the learned judge of the appellate court are not fully acceptable, but this court finds that the ultimate conclusion arrived at by the learned judge on the issue of maintainability of the miscellaneous case is correct and does not call for any interference. This court under Article 227 of the Constitution can supply reasons if the ultimate conclusion is correct. The judgment and order passed by the learned additional district judge second court at Kontai, dated 9th of April 2025, remanding the missed case to the learned trial judge with a direction to decide the rest of the issues that have already been framed, except issue number 1, with a direction to pass a reasoned judgment is not interfered with by this court. Accordingly, CO number such and such stands dismissed. There shall be, however, no order as to costs. The missed case was filed in the month of January 2019. Issues were framed. Parties have adduced their evidences, and documents have been marked as exhibits. In view thereof, the learned civil judge, Junior Division, First Additional Court, Kontai, is requested to dispose of the J. Miss.
This is double jeopardize. This is double jeopardize.
J. Miss case number 1 of 2019 in terms of the directions passed by the appellate court and in the light of the observations made herein before, as expeditiously as possible, but preferably within a period of 3 months from the receipt of a server copy of this order, without granting any unnecessary adjournments to either of the parties. Thank you, both of you, because of wonderful assistance from both of you.
We tried our best, but this required, this judgment is required. Why not? I am saying, entire Purbo Mendipur district will be facilitated by this judgment. Because of this fallacy, entire district, any preemption, this process is being adopted. But this judgment is required.
I'm grateful.
Only one thing, because yes, some new points were also argued.
No, my lord,
Both of
we
you
tried,
have,
my lord, our level. Assist you much. Great.
I've also tried in my own way. It's not that,
Extremely good. Great.
Thank you. Noted down.
Depending on the respondent, Your Lordship.
And the petitioner.
For all the reasons as aforesaid, this court holds that the instant writ petition is not maintainable. Accordingly, the writ petition stands dismissed as not maintainable. Since this court has already held that the writ petition is not maintainable, it is made clear that this court has not entered into the merits of the case made out by the petitioner. Petitioner is left free to approach the appropriate forum in accordance with law, if so advised.
Great. Great.
My lord, prior rising, my lord, item number 21, your lordships dismiss the matter on default. My lord, Miss Jui Dotto Chakraborty is appearing. He came out from his house, but sudden medical urgency, he came back to your house. My lord, she intimated me I was engaged in another court. I could not. 21. My lord, when your lordships called on 25, I missed.
21 recall. Yes, call the next matter. Yes.
I am for the opposite party.
We beg to appear for the petitioners. Before going to the impugned order,
The Lordship
the
already had
heat and substance of this case is very much clear and specific. First of all,
yes, only one thing. Yes, Mr. Chatterjee, you have got information.
The 151 application has been not addressed. Order has already been passed on 29th of June.
If they want to file a fresh application, I will not stand in the way on maintainability and all that.
Kindly grants me that liberty to.
ওই আগেরটাতে না
evidence is
Is in a
required to be taken at the
Mr.
earliest.
Chatterjee, considering the age, she was allowed to
Yes,
depose
yes,
prior to that.
These
Do
two
that,
are
come to the court. I'm not disturbing that. But you have want
these are on two
yes.
different footings. That I
You don't want to face the dock. That's another thing.
no, absolutely.
That's very necessary, Mr. Chatterjee, at
Yes,
times.
it's not that I will. It's a different person who is a relative of both of us.
On a lighter note, my lord, in Julius Caesar, when Decius tells Caesar that what reason do I give that you will not come to the Senate? California's dreams. And Caesar says the reason is in my will. I will not go. Like that cannot be.
Yes.
It's not a
Great
will,
point.
your lordship.
Yes.
It's the situation which.
Lordships. Yeah, back for the petitioner, 32. Before coming to the impugned order, the facts of the case is very much clear. The property, subject property, is the trust property. Annakali Bhor, Botokista Bhor, and Annakali Bhor. This. The petitioner, my lord, filed a title suit for declaration and injunction, mandatory injunction. After hearing in the learned court, second judge, City Civil Court, Calcutta, granted injunction application, ad interim injunction application. One mistake was wrongly detected. The 38/3 instead of 38/C has been depicted, but instead of 38/3. 38/D has been injuncted, 38/C has been injuncted also. Thereafter, my lord, I filed order 6 rule 70. That particular order has been granted by the City Civil Court, Calcutta. On the very particular acts, the opposite party.
When the amendment has been allowed?
Amendment allowed.
When?
Amendment 23. Na, pata kyo. Page number 23, Miller.
Yes.
Page 23. Page 23.
Order number 10.
Order number 10, 3724.
July.
That both the application filed by the plaintiff under order 6 rule 70 dated section 120 dated C724 and other under 150 and CPC C424 are hereby allowed.
Yes.
On contest, testing those applications to be part of the print and injunction application respectively.
Yes, so instead
both
of
the print.
38/3, it should be 38C.
Wrongly has been depicted.
Yes.
Originally 38/3.
38/3.
38/3.
Correct.
My lord.
There are two suits.
Two suits. One, after filing of this very particular suit, title suit, they filed an ejectment suit before this small causes court. After 2 months.
Property is same.
Suit property is same. After 2 months.
But the learned trial judge has said the suit property is not the same.
No, that is wrongly observed, my lord. That is why I have come before your lordship with clean hands, my lord. Kindly comes to page order of the small causes court 6/5/2026.
Not 6/5, 11, 18, 11, 2025.
11/8/25.
17 and 20.
Yes.
Both orders.
17 and 21.
Yes.
18, 11, 25.
Yes.
Order number 17.
Yes.
It is submitted by the learned advocate. 1, 2, 3, 4, 5 lines from that. It is submitted by the learned advocate for the dependents.
No, please kindly come to the last part in this instant suit.
Last part.
The subject matter, last paragraph.
Last part, right? In this instant suit, subject matter is premises number 38/3, Durgacharan Mitra Street, PS Bortala, Kolkata 6, from which the dependent are sought to be evicted.
This is wrong according to you. This is wrong.
It is wrong.
That is correct.
That is correct. Yes, then proceed. Whereas in the other suit, there are two premises, 38/C and
38/D. Both are injuncted. Earlier.
No. So 38/C and 38/D. So these are the suit premises in the other suit. So these two are different.
No. Firstly, when the matter was filed before the City Civil Court, 38/C and 38/D. But in the schedule,
Where are
it was wrongly.
Where are the plaints of these two suits? Please give me the amended plaint of these two suits.
Matlab, amendment plans, they have not submitted in the first suit. They have still not filed any amendment plan. Amendment was allowed. They have to
Amendment was allowed.
They have to file the amended plan by 6th of August 2024. Till today, they have not filed any amended.
Why have you not
But
filed
that
the
is not
amended?
at all mirror. Because during the period of the when the injunction was continuing, order 39 rule 4 was filed there, and in the with regard to the
If you say, please,
page
yes.
30, kindly comes to page
Sir, if you say that this is a wrong finding because it did not take into consideration the amendment, please show me the amendment. Please file the amended plan.
amended plan.
6th of August is the date fixed.
6th of August
So I'm getting it
2024.
after that.
6th of August 2024 was the date fixed for filing amended plan. This is 2026. 2 years
But
back.
not filed amended plan. They know everything. Order 39 rule 4 was filed. Regarding that, 39 or 38 by 3 was there.
Sir, have you filed the amended plan?
Yes. No.
Where is that copy of the amended plan?
I have no file. No file.
Then if the amendment you have not filed the amended plan, gone. What remains?
Affidavit in opposition they filed.
Sir,
Order
you are not
39 rule 4.
understanding. If you have not complied with order 6 rule 18, gone. Amendment gone.
Give me opportunity to file. Kindly give me opportunity.
That I cannot extend from here. If you want, I can adjourn it on your prayer.
And one another thing, this both should has to be, there has to be a issue directly and substantially. Kindly see their first suit.
Yes.
Give me an opportunity.
Kindly see the first suit. What is their reliefs claimed?
Sir, I'm not passed any order.
Order.
He wants time to take instructions on the prayer of the landed advocate for the
Yes. They asked.
Yes.
33, 34, 70, 80. 17, 80.
Let that date. Nothing will happen. Yes, yes.
That not visitation, man. This has been resolved. Not what
My lord,
Mr. Banerjee has,
my lord, only
Mr. Banerjee has said to
I have taken instruction, my lord. My lord, naturally, my lord, what has fallen from your lordship, my lord, she will comply with the order, my lord, of the trial court. Only thing is, my lord, let the parents, my lord, what happens, my lord, in the Calcutta University, the Rajabajar campus, in the Department of Psychology, what happens is, my lord, one has to approach the HOD. The HOD fixes a particular psychologist for that particular case. What my lord, my clients is proposing, my lord, is let them go together to the HOD. Let them propose a let my lord the HOD propose a particular name with the consent of both the parents. And my lord, Saturday
because HOD will fix.
Yes, no difficulty at all.
When both of you can go.
But any dates, any weekdays, not your lordship.
Tell me a date. Otherwise, he will say that you have not intimated. He will say,
No, your
yes,
lordship,
yes.
fix the date.
Yes. Please give a date convenient to both of you.
Saturday, Sunday, my lord, my client instruction is that is closed. That's why.
Except Saturday, Sunday.
Any day, my lord, your lordship.
Please suggest a date and time.
But if it's on a weekday, my lord, kindly, my lord, after 16th. If it's on a weekday, my lord, Saturday, Sunday, my lord, she was.
Just a date, time, everything.
17, 18, না, জজ সাহেবকে এখন বলতে হবে।
16th is the Rath Jatra.
Yes, any day after 16th, my lord, 16th.
Fix a date. This application petitioner.
Before my lord takes up the other item, my lord, item number 34, the next item is for release, my lord. Your lordship had asked us to take instruction, my lord. Item number 34. So Baripur court, my lord, and the concerned advocate is related to this matter, my lord. So, my lord, advocate Devashish, my lord.
30.
Advocate record.
Yes.
Advocate record.
Yes. Any progress there?
She is the member of the executive committee.
Yes, yes.
What's going on?
It's going on. And you are here.
26. Yes, my lord. I don't know the result. Maybe it's 2 p.m. Maybe it's 2 p.m. my lord.
Meeting is going on and you are here.
চলে গেলাম wanted me to remind you, Lord.
20.
Number 36.
I've asked you to remind at 4:15. Come at 4:15.
No issue.
The member is saying that no court from 2 p.m.
I don't know. No court বলে কিছু হয় না। It is no adverse order in the absence of both parties.
Yes, yes, yes.
Lord, after much struggle, my lord, I found out.
হবে না ভাই, এখন করতে পারবে।
Senior lawyer ভুলে যায়। Now item number.
বলতে হবে এটা। But ultimately, I found the.
But I also found.
Shuddha Salbhumik, my lord, the.
Finally, I could lay my hands, my lord, because my lord, somewhere in the file of the client, my lord, I my lord, got it. My lord, your lordship had put kindly peruses that, my lord.
Initially, my lord, when the building plan was submitted by one person.
Please give me a minute.
Sir, I'll just indicate what happened.
Mr. Mukherjee, do you have a photocopy of this? Because this is the original record. এটা দিয়ে দিন। Karmakar, you have a photocopy?
Yes.
Can give me.
Finally,
yes. Yes, I have got a photocopy. Yes.
Lord, what happened is, Lord, initially a structural plan was given, submitted by an LP. Lord, he only submitted that building sanction plan. It was an old structure. The structure was demolished, and it was found, Lord, that the area, when it was measured during the subsistence of that old structure, was not a bit more that I should have got. Lord, the only problem that happened is, Lord, they should have applied for, Lord, Rule 26, which was permissible. Lord, that they did not. Lord,
what is Rule 26?
Lord, kindly comes to Rule 26. It's not a case that once I submit a building sanction plan, that becomes sacrosanct. That is never the case. That cannot be the case. Lord, kindly comes to Rule 26. May I read out for your lordship?
Yes.
Deviation during execution of works. No deviation from the sanction plan shall be made during execution of any work.
Erection
notwithstanding anything.
Yes.
Contained in sub-rule 1. If during erection or execution of work any internal alteration within the sanction covers such and such, which does not violate the provisions of those rules indicated, the persons referred to inform the municipal commissioner by notice in writing and structural engineer, as the case may be, together with drawings incorporating the deviations and structural calculation in case of structural deviations. So this is exactly what happened. So, my lord, because the area had increased, so my lord, that's why the ratio, the different distance between two columns had also to be increased, because I had got a larger FA. That is exactly what happened. Now, my lord, after that, this I ought to have applied for. This was not done. In 2020, the COVID set in, this particular gentleman died. Not the entire building,
Who died?
not the LBS. The structure, the original structure in LBS, he died.
Who submitted the plan?
Yes. Now, yes, who submitted and obtained my lord, the building sanction plan. Now, my lord, kindly comes to Rule 47.
Yes.
Engagement of technical personnel.
Yes.
Every person who intends to erect, re-erect at a such and such provisions, Lord, rules engage for a residential building. Lord, this is not applicable to me. Kindly come to B. This applies to me. A building such and such or works any other underground licensed surveyor, architect and structural engineer for planning, sir. Kindly comes to 2. In case of death, resignation or removal of an architect, a structural engineer, a geotechnical engineer, a licensed such and such, reviewer as the case may be, has engaged, a fresh engagement shall be made forthwith and shall be notified to the commissioner thereafter.
This also you have not done.
This was done. And that's why
Who have been engaged?
now Shahidul Islam came. Shahidul Islam
Yes.
Your Lordship has seen. Lord, bottom your Lordship show a form of the structural stability certificate. Lordship gets it?
This is the notice of completion.
No, no. Lord, notice of completion. Form of notice of completion, my Lord is
Oh,
seen?
form of structural stability. Yes.
Now, my Lord kindly reads it. Your Lordship compares it. This is the only form that the corporation accepts. And the general specification is basically specification provided under the National Building Code. That's exactly what has been done. This particular gentleman has carried out inspection, indicated the date when he has carried out the inspection. And Shahidul Islam, he is taking the responsibility. Lord, today, so it is nobody's case that once a sanction plan is sanctioned, subsequent modification is not permissible. The question is whether the building is structurally stable or not. That's the only thing required to be not seen. The building tribunal proceeds not just in a cryptic manner because there is deviation, because there is no plan, so it has to be demolished. Completely ignoring structures, 2 structural stability certificates. Not that only. Not while granting regularization, inspections are held by the corporation. After being satisfied, only then this regularization is done. It is not so
Any
easy.
fees are to be paid for regularization?
I've paid 4.5 lakhs. I've paid. Else I would have received the CC.
Where is the order directing payment of those fees?
Lord, first, my lord, your lordship would kindly come to page. Eta koto? Page number.
Lord, kindly comes to page 64 once. Lord, this was the security deposit which I had to put in prior to, Lord, at the time of going for regularization. And
no, show me from the order what was the penalty levied.
Lord,
Show me from the order of the SOB.
Lord, penalty in, Lord, I think that portion has not been annexed. Kindly comes to page 67. Lord, the corporation has received on account of what it will be reflected. Page 67.
No, the order has to say that.
Lord, it has to say that, but I think it's a separate, Lord, assessment done. Lord, perhaps Mr. Mukherjee will have a copy of that. So,
yes,
Lord, Mr. Mukherjee will be having a copy of that.
May I just say one thing? Now, my lord, according to Mr. Kormokar, there are 2 structural stability certificate, and on the basis of the same, this has been done. Now, my lord, kindly see once the special officer building order, there only, my lord, one certificate has been mentioned, issued by one, my lord, Shuddhashil Bhumi. Now, he has relied upon, my lord,
Mr. Mukherjee only records also contains certificate.
I'm coming. But Rule 26 says specifically he has to apply that he has not done. Rule 47 says that if the LBS or other person died, then he has to intimate. Now, my lord,
has also not been done.
I'm telling you. Now, Shoidul particular, kindly see the date when he is giving the structural certificates, stability certificate. Kindly see the date of the special officer building order, 14th March 2023. And kindly see, he is saying he has inspected in 2024. Kindly go through the certificate. একটু বলে দিই বাবু
20th of January 2024.
He has inspected, then what he is saying, kindly go through the certificate, my lord.
No, because this order says
no, what order says?
To
page 66.
So he submitted.
Page 66. Now, my lord, if someone knowing fully well and receiving the memo appeal, kindly straightway come to my lord, page 69. Fine.
Yes.
Kindly turn to page 69.
69. Mr. Mukherjee, do you have a photocopy of this?
What copy of this I have?
এটা একই দেখে নে তো
69.
এটাই এই তো 17 But this is
by 69. Mr. Kormokar is showing that he has paid the amount. Kindly see the date at page 67, 6 December 2023. Right hand side top.
6
December 23. Right hand side top, my lord. Print date.
Yes, yes.
Issue date.
12 June.
No. This is
12th June.
12 June. I'm sorry. 12 June. Now, my lord,
June 2023.
now, my lord, he received the summons of the, my lord, appeal at page 69. Because, my lord, it has been annexed by the petitioner.
Yes.
Now, what I want to say, my lord, that the submission of Mr. Kormokar 2 structural stability certificate has been considered by the special officer building is contrary to the record. Second thing is that the technical member considering all the aspects. But if your lordship, may I just for repetition showing to your lordship once, but page 8 of the tribunal's order.
Yes.
But at paragraph 8, what are the infringement that has been specifically mentioned? Page 8 of the judgment.
Page 8 of the
appeal tribunal's judgment.
Yes.
Now the moot question line starts with, now we have made next paragraph, we have made close scrutiny of the CR in order to
So this I have seen. The structure stability certificate.
Now kindly see the next page. How Mr. Kormokar, kindly see the next page. From the structural safety point of view, it is found that the columns beam's position having changed causes danger of human life and property. How can you overcome if I put this question to
how can he say that without going into
there is a technical member?
He only becoming
then everyone, then the judge and the
Lord, we'll take the
I don't know whether AC is functioning or not, but that
is their
person,
problem. That is
number
their
AC,
problem.
AC chairman,
Lord, if the
everyone,
AC doesn't
tribunal,
function, I am sure,
tribunal
Lord,
member
the
will
brain
go there
will
and
function.
find out. Number, kindly visualize this aspect. Number, admittedly, there is deviation. Number, if
So,
he
Mukherjee,
can,
how much time it will take?
Now, let us come back tomorrow, my lord.
tomorrow will have পুরে আসুক বাইরে সার্কিট
Oh,
সার্কিটে যাচ্ছে তো
resolution taken?
Not to pass any adverse order.
Lord,
in the absence,
Lord, in the meantime, then Lord kindly protects me, Lord.
or if your lordship wants to keep it on Monday, my lord,
Monday.
Monday monthly list, right? Tuesday,
Monday.
Tuesday, Monday monthly list.
Kindly protects me, Lord.
Question of
How is he, my lord, interested? I don't understand. All points have been rejected.
What is
on the first
month's time has been given. Only 1 month is left. There is one more month
no
left.
question arises for demolition, my lord, because my kindly see the order improved.
Lord, records that undertaking.
No question
Lord,
of undertaking.
Then, my lord,
It is
these submissions, my lord, takes us nowhere.
He has made this submission, your lordship considered the order. Then your lordship was of the opinion that 2 months not left. What I am saying, your lordship has recorded that I have started the argument, could not conclude. If the matter is not reached on 14th, then that is the only problem.
Till
Then I will also have a right of reply, my lord.
under the same heading code. Huh?
My lord, your lord. Coming back.
Original site matter from 2 p.m.
The matter is, there is some urgency.
On original site matter, Mr. Bhattacharya, please wait.
building rules.
Both of you are ready?
Yes, yes.
Both of you,
We will appear. At least Miller from my end. Mr. Nag is also there.
where is Mr. Nag? Yes, Mr. Nag, both of you. All right. So, after the original site, I will take some break. Thereafter, I will.
Very well.
Please give me some.
Very well. 100%.
The officers also.
100%. Let us Miller resume at 3 o'clock.
Yes. 3. ওইটা কে না original side.
Original side.
2 p.m. original side.
My lord will be taking the 2 p.m. appellate side matters also.
2 p.m. you have taken a resolution.
There is a resolution already, my lord.
I appear for the petition in the origin side matter, my lord.
What do you want?
And then I'll kindly keep it next week, my lord.
You are for the petitioner.
Petition, my lord. That's there's a resolution, my lord. That's why I don't want to
Yes,
violate that.
on the prayer of have continued till 2 because this is the original.
My lord,
site.
only one thing, my lord. There is a Passover matter, item number 20, my lord. May it be taken up tomorrow, my lord, as there is a resolution, my lord.
There was a 2 p.m. fixed matter, my lord, 403, my lord.
Please wait, I am coming at 3.
Lord, today there is a resolution also, my lord. Can it be?
That's up to you.
My lord, kindly do not be harsh.
It says you will be appearing. That is why I am coming at 3. No. That's up to you.
The resolution subject to correction. It's not for not to.
No. That's
It's open to us.
yes. So I will come after at 3.
My lord,
Because officers also have to be given
yes,
some
yes, yes.
break.
My lord, maybe 10 minutes.
Because they have
before-
continued till 2.
Absolutely. My lord, if my lord comes, my lord, 10 minutes before 3, my lord, specially fixed of 2 p.m. My lord, that can be taken up, my lord.
Specially fixed 2
The
p.m.
next matter, the very
both
next.
Both of you are ready.
My lord, I am the petitioner, caveator I have served.
But please bring him if does not appear, Mr.
But that I cannot help, my lord.
Then you can come if you can bring the other side.
But I
then.
cannot.
Lordship, there's another 2 p.m.
Trial
fixed
court
ma-
by your lodged caveat.
All right, where is Mr. Bhattacharyya? Chole gelo.
Lordship, there's another 2
Mr.
p.m.
Bhattacharyya,
fixed
only one
matter,
thing, there
Lordship.
are 2 p.m. fixed matters. After that, please come at 3. Let's.
So great.
I'm for the petitioner, my lord.
Yes.
But there's no caveat. There's
The caveat.
no caveat.
Yes.
My lord, 788 days delay in filing condonation application was filed before the National Consumer.
788 days
I'll
delay.
explain, my lord. I'll explain, my lord. There is explanation, my lord. My lord, there was a. I am basically, my lord, the petitioner number 1 is the developer, and my lord, the rest of the petitioners are the, my lord,
Today is
owners.
the day for condonation of delay before the
because my
state commission and the national commission. In the morning also I have heard.
Yes, but the difficulty is this, my lord, that I was never given any notice. The order, final order judgment was ex parte. I came to know for the first time during when the execution application was served. And my lord, after that also, my lord, I was hospitalized. I'm, my lord, suffering from atrial fibrillation, and I'm suffering from hyperthyroidism. I couldn't go out of my house. But I've given day by day explanation. I'll just take your lordship through my application before the tribunal. Well, there were two things which the tribunal considered against me. That was, my lord, that I am the person who suffered, but what were the other appellants doing? My lord knows it is from the developer allocation, dispute is with the purchaser. The owners will never take any initiative. Only when I took the initiative, they joined with me as the appellants. They never took any initiative. They were also ex parte before the proceedings. But my lord, may I just, my lord, place the application first? My lord,
Your initial proceeding was before the district commission.
No, my lord, the state commission.
State commission.
State commission.
So, so this is the first appeal before the national
National.
commission.
And my lord,
Same judgments were considered. I think the same bench.
Same bench.
Same judgments were considered in that matter also. Might be a copy paste order also.
I see. My lord, the difficulty here is, had I been heard before the state commission, the entire complaint was time barred. My lord, I had entered into an agreement. They never paid. So I, my lord, cancelled the agreement. I gave them a check. After deducting, my lord, the earnest money, the balance amount, I gave them a check. They gave a
Where
notice.
is your application under section 5?
Yes,
Or the condonation, whatever it might
My
be.
application is at page 241 of volume 3, my lord. 241 থেকে start হচ্ছে 240 থেকে start হচ্ছে and my lord, the explanation for the delays from paragraph 19 onwards. And I have also filed a supplementary affidavit to, my lord.
What is your date of knowledge?
My lord, date of knowledge 30th, my lord, from the execution I came to know para 19. I have
19?
dated- Yes, my lord. 19. The order dated 15th May 24 first came to the knowledge of the appellants, which the execution application was
Please
served
show me the
upon
order of the
applicant.
state commission.
27, my lord. My lord, impugned order is, sir, my lord, I'm being late. Impugned order টা দেখতে যাচ্ছি।
Impugned order, your lordship will find only ground has been taken.
Taken a resolution, Mr. Mukherjee. You have informed me.
Live হয় নাকি? আরে না।
You are now the live streaming facility is there. So recording, you are there or not there. If you dispute that,
বলছেন বন্ধ করতে।
Yes, yes.
Let's see the order of the State Commission.
Page.
Page, my lord. It is in the first page of the Lordship brief also.
First page is the National Commission, not the National Commission, State Commission.
At page that is there.
Because the original proceedings were before the State Commission. Page.
319.
Page. 19.
It is. Your Lordship has already considered the State Commission, my lord, ultimately, my lord, rejected. State Commission, my lord, and
21.
decree has been passed expert.
What can be done, Mr. Mukherjee, if you don't appear?
No, my lord, my specific case, kindly see what is the case made out in.
Party degree is also a degree.
Absolutely, unless and until it is set aside or be interfered. Now, if your lordships consider the National Commission, the order, now, my lord, only reason is given that this has been, my lord, this has been established for the purpose of time-bound manner. And it is a time, kindly see once, my lord, the order of time-bound manner.
Order of the National Commission.
National Commission. This is the only reason.
Time bound.
Kindly see, my lord, internal page 3. Being a internal page 3, second paragraph. Being a consumer complainant, such condonation would defeat the purpose of the act. This is a consumer complaint matter and has to be decided in a time-bound manner. And condoning delay beyond a reasonable time without sufficient cause would go against the letter and spirit of the Consumer Protection Act. This is the reason. And the judge himself, you have seen I have seen the morning also, Mr. Chakraborty appeared. The judge himself giving the citation and other things. He has
cannot be given.
Absolutely. Kindly see those judgments, my lord. Whether this is at all applicable in my case. My specific case is that I have specifically stated the ground manner.
Same judgments have been referred to in that matter.
I found
that is why I told him the same judgments might be a copy paste order also.
No, here reason is different. In the earlier matter, if I am not wrong, reason was different. But here reason is the Consumer Protection Act is for speedy disposal, therefore it cannot be. But this cannot be a ground when I have specifically stated in my application. If your lordship see paragraph 7 and 8 of the revisional application. The summon which was served, it was kindly turned to page 4, paragraph 7. One Amitabh Raichoudhury received the summons on behalf of us. We don't know who is he. There is no employee, no one, and court has relied upon the same. But even the complaint could not satisfy the court that who is Amitabh Raichoudhury.
Sir.
Only thing execution is not 20. But kindly see, it is if you lordship see the order of the
Section 5 rejected, Mr. Mukherjee, no stay.
In section 5, we have learned from your lordship that in some cases
inordinate delay, you filed this application on 28th of October 2020. Mr. Mukherjee, you filed this civil revision application on 28th of October 2025. Today we are on June.
Now this matter has been, if you actually see the earlier,
Mr. Mukherjee, no stay.
But only thing, the problem will be that they have filed the execution. Execution was proceeding. Now, what happened, if today you are not being protected for limited stay, what will happen, this revision become infructuous. Kindly see the order of the.
What is the direction of the State Commission?
Yes, kindly see the order of the. Kindly 300.
Tell me what is the direction passed upon you? Execution proceedings when it was started.
My case is that from the execution.
Execution proceedings when it was started.
After 8 months.
After the National Commission. And what is the stage of the execution?
Condition order, if I don't bring the, because we have stated that we have filed the revisional application, if I don't bring the stay order, I have to comply.
Has to comply. Because from October 2025 till July, you are sitting tight, Mr. Mukherjee. Yes, what is the direction upon you?
Yeah, I just find it for your
to pay some amount.
In turn. Last date enter. Maybe 257 order.
Where is the order of the district commission? Sorry, state commission.
319 is the final order.
Final
Page 319, volume 3 is the final party decree.
319.
15th May 2023. Execution was filed 8 months thereafter. I came to know from the execution.
Why are you not registering the flat?
But they have not, if you see once. But
Yes,
that I have already stated. If you see one, paragraph 8.
What have you done with the flat?
Transfer to other, because no, what that is the reason. Whatever amount they have given, we have already returned the same. Kindly see once, my lord. We have already returned the same. But prior to filing the complaint, kindly see once, my lord. Kindly
Serve no stay.
no stay ultimately. Anyway, but then kindly give it to pray for adjournment in the.
That,
No, otherwise, my lord, what will happen if you already make that? Kindly see once, my lord. Kindly once.
Mr. Mukherjee, from October 2025, you have kept this matter pending.
Kindly see once, my lord. But sometimes, my lord, upgradation, your lordship's code is not allowing, my lord, upgradation, my lord. Kindly
All
consider.
right, it have revert back to its original position. করে দিন তো।
No.
Yes, Mr. Mukherjee, please look to the mentioning slip.
No, not before your lordship, my lord.
You have said, দেখান তো।
Not before your lordship.
দেখান।
Not before your lordship, for other two.
Please see, look at the mentioning slip.
But we have stated page 8, my lord. Kindly see once. But don't think otherwise. But kindly visualize one thing. If today, but this is. But then kindly do one thing. Kindly call for the records, my lord.
Call for the records of the National Commission.
Not National Commission, my lord.
National Commission, Mr. Mukherjee. I'm calling for the records of the National Commission.
Kindly grant some protection. Your lordship has considered, that's why from your lordship's mercy, your lordship update the matter.
Please bring a proper size.
Lordship's mercy is always there, my lord.
Either too large or too small. Will not fit, Mr.
Yes,
Mukherjee.
your lordship's mercy is always there, my lord. Go litigant.
Ashun.
Kindly short protection. Kindly see the last order.
By the order by the
Single page order.
Yes, next. Yes, Mr. Banerjee, where is your other side?
Other side is not here, my lord. I find there is no caveat. We have served.
You have said that there is a.
But there is no noting of caveat. But
you have served, Mr. Banerjee.
We have served, but that cannot be taken into account by your lordship, my lord.
But one thing.
There is no caveat.
Section 5
Yes, my lord, section 5 allowed.
allowed.
Yes, on a pretext. Order 9, Rule 13. Suit decreed ex parte, I am the plaintiff. Section 5 in connection with Order 9, Rule 13. Delay of more than 10.5 years. More than 10.5 years.
Length of the delay is not material,
Very
Mr. Banerjee.
Just the opposite to what happened in the earlier matter, my lord.
It depends, Mr.
Yes.
Banerjee.
Now, my lord, what has happened? But I remember those practice days, my lord. My lord, now what has happened? My lord, the learned code below.
Banerjee, you don't have a very good case on merits.
Very good case. Absolutely.
Why are you fighting out on Section 5? Please fight out on the merits of the matter.
Well, at the decree that was passed, they were aware of it. They had entered appearance in the proceedings, the suit, and there were order sheets in which their appearances were recorded. And now they say this is for the first time that we come to know about the suit.
Is it a case of non-service of summons?
No, no. Malad, here, service was there. The defendant, some of the defendants entered appearance. The defendant who is now applying under Order 9, Rule 13 says, I had no knowledge. There was no service of summons.
No, so they are cases of non-service of summons.
Non-service of summons.
I'm saying you are saying no.
I'm sorry, my lord.
I'm not asking your case. I'm asking their case.
Very.
So if it is a case of non-service of summons, now the ground under Section 5 of the Limitation Act and Order 9 Rule 13 is the same.
Same.
If the Section 5 is allowed, what remains to be decided in Order 9 Rule 13?
Well, nothing remains, my lord, now.
So virtually Order 9 Rule 13 is allowed.
But if no, my lord, only one thing the court has kept.
Banerjee, please think about this.
But I have
Section 5 is allowed.
My lord, I have.
It was the delay. So he will explain why he did not appear since the non-service of service from the date.
But
this entire delay, reasons is the same. Section 5 is allowed automatically. Order 9 Rule 13 has to be allowed. What remains?
My lord, I would invite your lordship's attention, my lord, to the order impugned. My lord, here the court records.
Eviction suit.
No, no, no. Declaration injunction. My lord, I did not file any execution also. I am the plaintiff in the suit. My lord, they say that from the notice of the Kolkata Corporation, I for the first time came to know about the suit. Kindly seize the impugned order, my lord. And the lady who is the number.
Discretionary order, Mr. Banerjee, the court has exercised discretion, allowing, because there is a distinction. When it is against an order under Section 5, there are two ways of looking at it. If it is rejected, what is the scope of challenge before a superior court? And if it is allowed, what's the scope of challenge?
My lord will.
One line of decision says that if it is allowed discretion, please don't interfere with that.
My lord.
And if it is rejected, yes, you can consider the reasons. So those are the recent decisions.
My lord will.
So if the discretion has been exercised, Mr. Banerjee.
My lord, no discretion has been exercised. My lord, the discretion should be judiciously done. Here the court has proceeded on the presumption that on the date on which they had the notice of the corporation.
I will brought the recent decision of the Honorable Supreme Court.
My lord, I have not brought, my lord. I just want to show before your lordship, my lord.
By the order impugned, the application
But
Sir, come
kindly,
back
but
15th.
kindly stays it for a few days, not to take up on the next day, my lord. Otherwise,
18th you have said, that is why I fixed on 15th.
under any circumstance, it's not reached, I will be.
Mention,
Very well. I will.
yes. Yes. Call the next matter.
Item number 266.
My lord, in this matter, I'm appearing for petitioner. My lord, in this matter, what has happened? Based on section 13(2) notice that was served in the year 2011, your lordship kindly come to order impugn first. I've annexed the certified copy.
What happened? What are you challenging?
My lord, based on a time-barred notice under section 13(2), the bank has initiated proceedings under section 14 and obtained an order from learned CGM, and accordingly they have taken possession. Prior to taking possessions, I filed this application before this honorable court, but due to paucity of time, the matter couldn't taken up. And in that meantime, my lord, bank has taken possession on 14th. 14th of June. They have taken possession. My right now urgency is that, for that reason I mentioned before your lordship, that my sons and daughters, all books, even the school dresses are being locked by the bank.
So what do you want? You want to take it back?
Yes, yes, my lord. My lord, even my lord, I must
One
be
thing
candid.
I'm telling you, the proper forum is the tribunal.
Yes, my lord.
So, which bank?
Union Bank, my lord.
Who appears for the Union Bank?
Difficult to say.
Where is the office?
My lord, I serve.
First street.
I serve. I serve.
At time, Mr. Dipanjan Dutt also appear for Union Bank. I know.
Let Mr. Dutt.
Serve and come back. When can you come back?
My lord, I have urgency. If your lordship directs me tomorrow, my lord, I can serve.
He is in court.
Tuesday. At Tuesday.
Next Tuesday.
14th.
14th, my lord. No problem. But even my lord, I served. The copy of the petition, I served.
But civil revision, unless there is a direction.
Yes, my lord.
Nothing.
Yes, my lord. No problem. I will serve Mr. Dutt.
First, second is it's not maintainable.
My lord,
before this 227, but
my lord,
considering your limited prayer, the prayer which you are now seeking,
but I am challenging. I will sort of satisfy your lordship on the point that based on a time-bound notice of demand, they have acted.
you can
They,
approach the DRT for that.
yes. But equally, your lordship has jurisdiction. Reason being, my lord, the court doesn't have jurisdiction. I am on the point of jurisdiction. CGM doesn't have the jurisdiction to pass such erroneous order. Even I can approach before that learned tribunal.
Mr. Thakkar is laughing.
My lord,
No. It was on a lighter note because it
yes.
on similar argument you made. That is why I told you.
My lord, alternative remedy. No, I appreciate. My lord, I appreciate. No, my lord.
Petitioner is directed to serve a copy of
I am serving.
I can hand it, take it over.
My lord, here and now, my lord, I am serving. OP3, my lord, although I made a party, my lord, his presence is not required.
the Yes.
I'm for the petition in this matter, my lord. But I am the plaintiff in a suit for declaration and injunction, my lord.
What is the impugned order?
My lord, by the order impugned, my lord, what has happened after the conclusion of the evidence of plaintiff's witness, my lord, the DW1 has filed an affidavit in chief. On that day, they have only filed. On the next day, the DW1 same person has filed another affidavit in chief. I have filed an application paying for rejection of the subsequent one, my lord. The court has said that since it was not tendered on doc, the first one, as such, the first chief will have a zero value and the second will be
Who are you?
I am the plaintiff in the.
Yes, so he has, though he has filed two affidavit of chief, but he is not tendering only one. Restricted
But
that
the second one is.
Court has restricted to that. What's the difficulty?
My lord, once the chief has been filed, duly notarized, it is already, my lord, on oath. And my lord, my lord, from the day it has been filed, it continues to, my lord, it carries the, my lord, weight of evidence, my lord. It cannot be either, my lord, withdrawn or surpassed or, my lord, non-pressed in any manner, my lord, whatsoever. Order 18, Rule 4 says, my lord, the chief has to be, my lord, tendered on affidavit. That has been done, and my lord, there is no requirement under Order 18, Rule 4.
No, there were two affidavits filed.
Yes.
Only on one on 17th of July 2025 and another on 13th of August 2025.
Yes.
So the court will consider only the 13th of August. Will not consider the 17th of July.
Here I join the issue, my lord, that it cannot be, my lord. Order 18.
What is there? What is the difference between these two affidavits?
Material changes.
What are the changes? Please show me.
Yes. The first chief, my lord, is at page 23 and second is at page 27.
What are the material changes?
Yes. Kindly takes up page 23 once, my lord. The last paragraph, my lord, with regard to para 7 of the alleged plaint, kindly takes up next page. Page 24 now compares it, my lord, with page 28.
So up to first page, it's same.
Yes, no, it was general denials of the, my lord.
Yes, that's same.
Yes, that's same, my lord. With regard to para 7, my lord, kindly sees in page 24, my lord, it was contained in only 2 paragraphs, or I say 3 paragraphs. Kindly takes up now page 28. It goes up to page 31. Several documents, these are not even part of the, my lord, written statement. That has come up, my lord. And then, my lord, paragraph 15 and 20. Now, my lord, kindly takes it up. There, my lord, written statement is which is at page 17. My lord will not find that this is there.
This is of PW1.
PW1. And he takes up page 17 once, my lord. That's the WS, my lord.
Have you brought the three-judge bench judgment of the Honorable Supreme Court in 2003, authored by Justice Sinha?
I have brought one judgment that is of 2012 to SCC 196. That's the interpretation of Order 18, Rule 4 and 5, my lord, with regard to whether there is requirement to tender the evidence, which has been.
I think 2003 judgment has been considered here.
May I only check? The relevant paragraphs are, my lord, paragraph 63 to 78, my lord. Which
Paragraph
63 to 78, my lord, which deals with the, my lord, this subject matter, my lord. Finally takes up 77 and 78. 77, my lord, for all this, it cannot be said that in Army Trading Corporation Limited, it has been laid down.
Please give me a minute.
Yes, my lord.
I think 2004 one SCC is by Justice Sinha. Any one of you have is carrying those gadgets? 2004 you are having 2004 one SCC 702.
May
Please
only.
pick up. This was the first decision relying upon a Bombay High Court judge.
Yes, yes. Then, my lord, this is that one.
Yes, please give me that.
That has been clarified in this.
Yes. So SCC is 2004, I think. In
My lord,
IR
I
it's
know Army
2003.
Trading, my lord, in that I do not have it physically, but in that judgment, a Bombay High Court judge, and these are, my lord, there, my lord, within, my lord, in this judgment
That
itself.
judgment delivered by Justice Sinha, SB Sinha.
May I only check?
Please check up. Yes, agreed with the view of Bombay Amir Trading. Yes, I think this is the judgment. Irrespective of whether the case is appellable or not, paragraph cannot be read. The main paragraph of the decision were up to the first place.
Yes, yes.
On SCC Amir Trading.
Is
Amir Trading.
yes, who is the author? 702.
Yes,
Yes.
Amir Trading.
Yes. Is it by Justice Sinha? SB Sinha?
Yes.
On order 18.
Order 18, 4 and 5.
Yes, yes. I think that was the first judgment after. Yes. Paragraph 78. In our view, there is no requirement in Order 18 Rule 5 that in applicable cases, the witness must enter the witness box for production of his affidavit and formally prove the affidavit, as it is such witness is required to enter the witness box in its cross-examination, and if necessary, make himself, unless the right to further it cannot be said that Amir Trading it has been held as an absolute rule. This impermissible produced in the form of such affidavit cannot be treated as a unless.
This is what I'm submitting
This is
before
the
my lord.
distinction from Amit Trading. Mr.
Yes.
Thakkar, are you, do you have that Amit Trading?
Yes, I also have.
Yes, because there it has been held that chief is to be tendered.
Yes,
The
that
person is to
distinction
come
has
to
been,
the
my lord,
box.
made, my lord, in this. That has been clarified here, my lord, in this
The three
judgment.
judgment, I think. Yes. This is a three judge
Kindly
bench
takes
judgment.
up.
Amit Trading is three judge bench judgment.
Understand. Kindly takes up para 75. The court has said
Yes.
so.
What is the strength of this? This is two judge
This
bench
is true.
judgment.
Kindly takes up his para 75.
Yes, I've seen paragraph 77.
75 once, my lord. The court is saying that in Army Trading, the Honorable Supreme Court has not, my lord, totally, my lord, agreed with the view of the Bombay High Court. 75.
Yes. So now he has to come to face the cross-examination. He chooses only one. You can take the benefit of the other if you want to.
But kindly consider on the first day, the moment he has filed it, the moment he has filed it, my lord, his chief has been done. So, my lord, if his chief, if his examination in chief, my lord, is before the court, is on record by way of affidavit, my lord, on the next day, my lord, it was only left, my lord, that he would have been, my lord, cross-examined and re-examined if required. Well, it cannot be said that since he has not come on dock, which the court below has said, kindly sees the reason. It is found, it is pertinent to mention that affidavit was not tendered on dock. The affidavit in chief, until and unless is tendered through witness, does not prevail as substantive. This is the only ground. But this is incorrect, my lord, on the face of it, my lord. Apart from that, there are other high court judgments also, my lord. I didn't bring today, my lord.
Sir, why are you trying to delay your suit?
My lord,
What is the suit for?
Suit for declaration and injunction, my lord.
Why are you trying to delay your suit? It will unnecessarily, your suit will be delayed.
I understand, my lord, but my lord.
All right. By the order impugned, the learned trial judge accepted one of the affidavit in chief and one of the affidavit in chief filed by the defendant. Full stop. The learned advocate appearing for the petitioner submits that
It's a slightly unusual matter coming up from an order refusing an adjournment.
Refusing an adjournment.
And that too, my lord, by an arbitrator. I'll tell you, Lordship, the difficulty is, my attorney would not have filed this. The difficulty is this. Claim is dismissed, in effect, by an interim award. The prayer in the claim and the counterclaim are inextricably connected because it relates to dissolution of a partnership firm. Claimants.
Who are you?
I am the claimant. Claimant says partnership firm stands dissolved on the death of the partners, and otherwise, in the alternate, I have dissolved it by a notice. On that, he takes out an application for interim award for a preliminary decree recording dissolution. That application is rejected. The order is made, application dismissed, no orders. And the matter proceeds. Now, against that, he treats it as an interim award because he prayed for an interim award on a preliminary decree or a preliminary award. So, against that, he files a 34, which is pending. It is to come up before the commercial court at Rajarat on 21st July. The counterclaim is reconstitute the firm.
Counterclaim is?
For reconstitution of the firm. Yes. Because the legal heirs want to be brought on record. So counterclaim is reconstitute the firm. So that is why the predicament, that is the counterclaim, because now it in effect, it decides the counterclaim also. Now what is left to be decided is just the decree directing draw up the reconstitution deed, because that is all that is required. Because if the dissolution is rejected, consequences, the partnership deed has to be drawn up. So it is now just the ministerial order has to be of drawing up. So that is the difficulty. So in that circumstances, it was brought to the notice of the learned arbitrator that my 34 is filed, the 36 is pending, and also the defer the hearing fixed for today. So the learned arbitrator declined, proceeded with the cross-examination on that date, and he's again fixed a date for cross-examination. The impugned order, my lord, is at page 172. Interim award देखो ये है तो मेरा ब्रीफ ये पढ़ना दो ब्रीफ तो पूरा मेरा ब्रीफ में मोड़ा हुआ था पेज नंबर्स देखो बस पेज नंबर बैक शीट का है पेज नंबर इसमें है तो बाकी का impugned order
Who have not applied for stay in 34?
I have applied.
Coming up on when?
It's coming up on 21st July. With then there's a section.
And what is the next date here?
The next date here is on Monday, but the other side has circulated a letter that they will be seeking adjournment because of counsel's difficulty. I think that is the reason why Mr. Agarwal mentioned your lordship, troubled your lordship to take it up today. I told him that this can now wait till Monday because the Monday hearing will not take place. But he said since lordship has kept it at 2 p.m., might as well.
Because
Monday they have circulated a letter that they are in difficulty. 14th. It's fixed on.
What might be the next date?
Now, my lord, 14th
Will it be after 21st?
No, it will be on the 17th because they have suggested the date of 17th.
17th.
That these are the two orders which were there. Yes. So 14th is my lord's order fixing the further proceeding on 14th, the learned arbitrator's order. And the next page, my lord, is their communication saying that 14th they are in some difficulty. They should, his lordship should adjourn
any date between 20th to 23rd.
Yes. Then the proceeding before the district, the commercial court is on 22nd. 21st. So if it is held on 17th, again there's a difficulty.
Yes, because here, Mr. Thakkar, your limited scope is that prayer for adjournment is refused.
Yes, that is why I said.
This letter which has been circulated that 17th or 20th to 23rd. If you can agree to anything after 21st, I think
yes, but for that the other side has to come.
Who is the learned advocate? Can he
The
appear?
learned advocate. There are three. There are three respondents, so three participants. In effect, one, but who's got the counterclaim, who is carrying the proceeding. Actually, one because he is the one who's got the counterclaim for specific performance.
Yes.
But so we'll give notice and come on Monday.
Advocate from High Court, no.
Yes. Two of firm क्या है दो बाकी दो and yes, all from High Court. One from the original side and two members of the Bar Association. One attorney, advocate on record on the original side, and two from the association.
So I'm keeping it tomorrow.
Please, ma'am.
You serve them a copy and the notice. Can you do it by today?
Yes. Today they might have left. We'll call them. Then, you have their numbers. We'll serve them by email or WhatsApp, whatever. Only one request, but not at 2 p.m. I'm in some difficulty at 2 p.m. The matter fixed with the district judge. If it could be any time in the first half. This will not take time, my lord. 1:15 we can come, my lord.
Acha.
1:10,
thing. It might be taken up before that also.
Yes.
Usual course. Only one thing.
But that will be very surprising if your lordships could take the usual course.
If it is in case it is not reached, bring the other side at 1. I will be taking.
Deeply.
Serve a notice in that way.
I will do it right now.
Petitioner is directed to serve a copy Yes.
Grateful, deeply obliged. Abhi jao. Abhi.
Yes, call the next matter.
All the advocates appearing in the arbitration.
Pass over next.
Your Lordship.
Where is Mr. Bhattacharya?
He will soon come. My lord, here, before taking your Lordship to the impugned order, my lord, here initially an order of eviction was passed. When the eviction order was passed, an appeal was preferred. Now, my lord, in the appeal, there was an order of stay of the order of eviction.
Of the order of eviction?
Order of eviction. Now, my lord, the stay order was subsisting for some time. No status quo. It was stay of the order eviction order. It's not status quo. It is, my lord, stay of eviction order. It's not status quo. Now, my lord, thereafter, the interim order expired. And the interim order, there was no interim order for near about 10 to 11 months. And thereafter, this honorable court passed an order saying that the interim order of stay will continue for a period of 5 months. So that interim order of stay continued for 5 months and automatically got vacated on May 15.
On
May 15.
2026.
2026. Now from May, I will take your Lordship
15, 2026.
May 15.
So interim order was subsisting.
Still
by this court. Interim order passed by this court.
By this court. Because lower court, while the trial court refused to extend the interim order, looking at the conduct of them. And another point, my lord, I will place the order of this court. And a cost.
Then what happened? Then
Just a moment. And also when the interim order was extended, a cost of 30,000 was imposed on them, considering the conduct of the opposite party. Now, my lord, thereafter,
cost paid.
Cost paid. Belatedly, but paid. Now, my lord, from 15th May till 16 June, there was no interim order. And my lord, after waiting for 1 month, and previously it was for 11th month, we took possession of the property. We took possession of
when?
On 16 June. Dates are very important.
Yes.
16 June, we took possession of the property.
Yes.
Now, my lord, 17 June, an application was filed before the trial court saying that
they filed
saying, please give me an order of status quo. An order of status quo was 151, not under order 39 rule 4. Well, that
section 151 application for status quo.
For status quo. Well, the prayer I am praying in the circumstances.
All right, I will come to that. For status quo.
Status quo order.
What happened?
Status quo order was passed. When Malad there was they lost the position.
So status quo order passed when?
June? 17 June, the next day. On next date.
No, you said application filed on 17th of June.
And 17 June, the order was
So same day order was passed.
Same day order was passed. Same day order was passed for status quo.
June 17, 2026. Status quo order passed.
Status quo order passed. Now, my lord, when the status quo order was passed, the property position was with us. The position of the property was with us. Now, my lord, lordship knows the next part, they filed a writ petition. The writ petition they withdraw it with the liberty to.
Don't depend on my memory because
on 19 June, a writ petition was filed by them. saying that the action
19th June.
19, no, the writ petition was filed earlier, but order was passed on 19 June by your lordship.
June 19, order passed in the writ petition.
In the writ petition. They withdraw the writ petition with the liberty to approach the court. Now, they say in the writ petition that is not illegal, my action is arbitrary. Now, thereafter, on the basis of that, a fresh application they filed before the trial judge, seeking twofold prayer. Prayer is, one is the variation of interim order, because the status quo order is subsisting. And second is, an order of status quo ante.
Two applications filed.
No.
One application, two prayers.
Two prayers.
One is that application filed when?
That application, was filed. Date is not here.
All right. What are the prayers?
Prayer, I am placing in the premises. The appellant.
In short, what are the reliefs claimed?
Is to vary the order of 17 June. That is the order of status quo.
All right. To vary
the order of status quo.
17th June. And
removal of padlock by granting an order of status quo ante.
Removal of padlock.
Removal of padlock. So two prayers in one application.
Yes. So, and this has been allowed.
This has been allowed.
Against which we have come up.
Now, against that I have before your lordship. Two order, and then I take your lordship to the order impugned. First, take page 105. 105 is the order whereby the interim order was passed by this court, because the earlier the rejection order was passed, there was no extension of interim order by the trial judge. So, directly come to page 106. I will not trouble your lordship with all the order.
So, this is the order by which for 5 months status quo was passed. Yes.
Heard the parties, the paragraph 5, I am placing at page 106. Heard the parties, the court held the allegation that the learned advocate who had been engaged had taken no steps was unfounded and not proper. Learned court was also of the opinion that under section 148 of the Code of Civil, the stay could be extended for not more than 30 days. This is my opinion was an incorrect assessment of the situation. Section 148 of the code does not come into operation of situation of this nature. However, the petitioner admittedly did not take steps with expedition. As such, opposite party must be compensated. Cost of 30,000 shall be paid to the petitioner to the opposite party within January 10. There shall be an unconditional order of status quo with regard to nature, character, possession of the property till January 10, 2026, and the same shall continue for a period of 5 months till disposal of the appeal, whichever is earlier. The learned court is directed to dispose of the appeal, preferably within aforementioned period. If the appeal cannot be disposed of for unforeseen circumstances, the petitioner can renew the prayer of status quo. Now, what happened thereafter? Kindly take thereafter the next page, and thereafter lordship will find that in each and every occasion they took time in the appeal. Kindly look at the page 108. A petition is filed on behalf of the appellant praying for adjournment on the grounds stated therein, along with a copy of the order. Adjourn. Then next 109. 2 days fixed for appeal, stay application, hearing for the maintainability. Petition seeking adjournment on the ground of physical incapability of the advocate. Then 110. So this is out of charge, but all day they have taken adjournment, and they never was keen to do hearing of the matter. Now, here, now new application, I am not bothering your lordship with everything, Here, kindly come to page 118. 118. This is important because, on 16 June, kindly keep it in mind, that we have taken possession of the property. Learned advocate for the appellant and learned advocate.
Which page?
118, I'm sorry, my lord, 118.
118.
8. The variation of the order that they sought when I was in position.
Yes.
Learned advocate for the appellant has also filed a petition praying that the order directing the parties to maintain status quo be extended till next date of it. It appears the court has passed an order of stay, video order dated 19/11/2022, and such was extended from time to time. On 3rd June, the appellant has filed an application seeking extension of such order of stay, but such was only kept with the record. Video order dated 10/9, such petition was rejected. Therefore, though such order of stay was not extended any further, the appellant aggrieved approached the Honorable Court, was pleased to pass an order 15/12 directing there shall be status quo with regard to till January 10, and such will continue for a period of 5 months or till disposal of the appeal, whichever is earlier. The Honorable High Court at Calcutta has also directed if the appeal is not disposed within such period, appellant can renew the prayer of status quo. It appears that hearing of the appeal has commenced. The appeal has not been disposed of. Hence, considering such and also solemn order dated 5/12, both the parties directed to maintain status quo in regard to nature, character, position of the property in conclusion of the instant appeal. So, my lord, next day it's fixed. This is the thing. So, my lord, the purport of this order is that my possession over the property has been established by this order because there is an order of status quo passed. Now, my lord, after that, Lordship's order is at page 119. Next page. The petitioner has approached this court being aggrieved by an action of authorities of Port, Kolkata, putting a padlock on the prayer of learned advocate for the petitioner. Leave is granted to the petitioner to file supplementary affidavit. Supplementary affidavit filed today is taken on record. Learned advocate appearing for the Port Trust Authority. Port Trust Authority raises an objection as to maintainability. After some argument, Mr. Bhattacharya, learned advocate, appearing for the petitioner, prays for leave to withdraw the writ petition with liberty to take appropriate steps with the proper forum in accordance with law. In the light of submission made by Mr. Bhattacharya, learned advocate for the petitioner, the writ petition stand dismissed as withdrawn with the liberty of the petitioner to approach the proper forum seeking appropriate relief. In the light of submission made, the issue has not been gone into. So this is expeditiously. Now, well, let's look at the prayer of the new application, which is at page 128.
128. Yes.
128, well, I was placing. Oh, there is an unfortunate incident today. Ipshita Banerjee.
Yes.
She
is expired
today.
When?
We got the news around 3 o'clock. Around, I was there in court room number 32.
She was doing some NGO work in Kaza, Himachal Pradesh.
Lack of oxygen.
Where she expired. Now, how the body will come? It's not.
And it is such a.
It's a shock because she was just 55 or 56.
Two sad news. One is yes.
Sengupta.
Yes.
Lived his life.
Yes. This is really
shocking. Really shocking.
To enter the middle room of their library, it will now become very difficult. When I often go, I have friends there, he's there, a lot of people are there. When we entered the middle room where Mr. Pal used to sit, the other table, Mr. Banerjee used to sit with Mrs. Banerjee. It is very difficult. They used to sit together, chat across the table.
And whenever you go, they will offer tea and coffee. And
yes, of course.
Be that as it may, Mallet. Now, Mallet, kindly take page 128. In the premises, the appellant petitioner humbly prays that honor be graciously pleased to, Mallet, first portion, modify or vary the order dated June 17, 2026 and direct removal, and second portion, removal of padlock from main gate of the appellant and or direct status quo ante as on June 10, 2026 as per such. So twofold prayer was made before the trial judge. Now, my lord, kindly look at the impugned order. It's very interesting read, my lord. May I place it, my lord, the impugned order? Before proceeding to dwell with them into the merits of the petition, I'm starting from fourth paragraph. Under the consideration, I find it proper to lay down checkered history leading to preference of the petition. The appellant preferred an appeal being aggrieved by an order dated 11th August 2022 passed by Shama Prasad Mukherjee Court. The appeal was filed in the court. District Judge Howrah and VD order dated the appeal was transferred to this court. The appellant had sought stay of operation of the impugned order and VD order number such and such. This court was allowed the prayer of stay. The order of stay was extended from time to time. 2025 on 29/1/2025, the appellant did not take any steps. And on 3rd was fixed for steps, the appellant and hearing of the appeal. On 3rd June, the appellant prayed for extension of the order of stay till disposal of the appeal, and such petition was kept on record, and on such and such was fixed for hearing of such petition. On 28th August, next day was fixed on such and such, hearing of such petition was fixed on 3rd June 2025. The respondent and the appellant had both sought for adjournments, and eventually on 10/9 the petition dated was rejected on contest. Being aggrieved by such order of rejection, the appellant approached the Honorable High Court at Calcutta with a order dated 24/11/2000 as pleased to direct to maintain status quo of 2 months or until further, whichever is earlier. The Honorable Court of Calcutta thereafter 15/12 was pleased to pass an order. There shall be an unconditional order of status quo with regard to nature, character, position of the property till such and such, and the same shall continue for a period of 5 months or until disposal of it, whichever is earlier. Though the order of the Honorable High Court at Calcutta was pleased to direct the court to disposal of the appeal within the aforementioned period, and if such appeal was not disposed for unforeseen circumstances, but it is not unforeseen circumstances, that is due to the adjournment on the part of the petitioner of the opposite party, the petitioner who has provided liberty to renew the prayer of status quo. Therefore, in consequence of such order, parties were under the direction to maintain status quo. Well, let's mark this portion till 15/5/2026. As the appeal was not disposed of, the appeal hearing was commenced on 17 June and thereafter 8 July 2026, 29 July and 1st August to the was fixed for further hearing. VD order 17 June, the court had directed the parties to maintain status quo in regard to nature, character, position of the property till conclusion of the appeal. In the meantime, appellant filed the petition under consideration and submitted that the respondent has closed the main gate by putting a padlock. It was also stated that due to such act that undermines the orders of the court, the appellant has filed a writ petition before this Honorable High Court, being such and such, and the Honorable High Court of Calcutta VDA order was pleased to allow the appellant to withdraw the writ approach this court. On perusal of the petition upon consideration, it appears that appellant has stated a state officer being a quasi-judicial authority had put the padlock on the main gate of the jute mill of the appellant, and such had it defined amounted to interference in the administration of justice and was contemptuous. The respondent had filed a written objection against such petition, stating that there is no interim protection subsisting on 16 June and the possession of suit property was taken as per law and after following procedural aspect. It is further stated it was a negligence of the appellant in not seeking proper extension of the order of stay and who cannot claim benefit thereafter. With such assertion, the respondent has prayed for rejection. The learned advocate for the respondent asserted that such a petition is not in consonance of civil rules and order, as such contain that one prayer in single petition. If Rule 22 is considered, it will appear that such stage must contain not contain more than one prayer or one series of alternative prayers of same kind. The prayers put forward by the petition on the contrary modification, variation of the order and removal of the padlock from the and direct preservation of status quo ante on certain. Learned advocate of the appellant submitted the status quo order was altered on 16/6/2026 by putting a padlock, which appellant has prayed for modification of such order and removal of the padlock. If the prayers are considered in unison, it will appear the prayers appears alternative prayers seeking achieve the same result. Hence, it appears it cannot be held such petition was not in consonance of such and such. Learned advocate has also strenuously argued that the padlock was put in place on such and such during course of for the learned advocate vociferously admitted that the padlock indeed was put in the place of the main gate. It is further asserted there was no order of status quo or any order of stay for which no illegality has been committed by the estate officer. Learned advocate for the respondent went further to submit the act of putting was devoid of any illegality. Learned advocate for the appellant counter submitted the appellant had reached final stage of hearing fixed for 3 days, and on first submission the two for the respondents and such action is such. Now, here from the reasoning started. I have perused the records and it appears that on 16 June 2026, there was indeed and no order of stay. Any order directing the parties to maintain status quo. Only such could not be seen a reason for the estate officer to act with such unexplained sense of urgency. On a pausing here for a moment, for 1 month, there was no interim order. So there was no unexplained sense of urgency. Then, the estate officer must have knowledge that the court was scrutinizing the legality and correctness of the order, and past such scrutiny has reached penalty stage. Each and every order passed by authority should not only be legal, but also be reasonable, adhering to the all notions, pillars of natural justice. The order of any action of the authority should not only within contours of law, but be reasonability must be embedded. I don't understand this. Well, the theory of administrative law cannot be imported in a civil procedure. It's a procedural law, and that is an administrative. Well, what is reasonable, what is unreasonable, what is arbitrariness? Well, this is, in my humble submission, is a subject matter of rich jurisprudence. It cannot go in a civil procedure. He has to see my act is correct or not, or the parameters of granting order. So that is the first point. Then should not only be then many a times the litigants approach the court seeking an opportunity to bring specific order of stay from higher forum, and the court does not stand pleased to grant one opportunity to such litigant to bring specific order of stay. If such orders are not brought forth, there stands no further hindrance to proceed in accordance with law. Such a single opportunity should have been given to by the estate officer, especially when order of the Honorable High Court subsisting provided the appellant liberty to renew. Well, I don't understand where from he imported this proposition of law. That before, if there is no status quo order, there is nothing, I have to approach a court. I don't know, I have never heard of. Then, the heavens would not have come crashing down if the estate officer would have provided an opportunity to the appellant to bring forth any order. It's like Kajir Bichar, why heavens will not fall. The instant appeal is for the year, and there was intermittent periods where there was no order of status quo or order of status quo, but such act was committed by the estate officer. The action of any authority should conform theory of legality. The action of any authority should conform to the theory of legality as also intertwined with such theory of reasonability. What reasonability? It's a procedural law. Well, there is no question of reasonableness or arbitrariness. Well, it must have been influenced by my learned friend that, and it's continued. Such a concept which evolved from a landmark case.
He appeared.
I think it is suddenly arbitrariness in a procedural law.
What is it you appeared there?
He drafted or advice. Lordship thereafter.
Drafted by you.
I'm sorry.
Written notes drafted by you.
Nothing was drafted by me. I was not a instrumental in anything. After courtroom number 19, I was just informed that the matter has been filed and it is being moved. His
benevolence and his thought process, does not match with actual reality.
Because my lord, next line, such a concept which has evolved from landmark UK case associate professional picture versus Wainsbury Corporation also seeks that an action by an authority can be within contours of statute but still stuck down as unreasonable if it is irrational or discriminatory or grossly disappropriate to the object tries to achieve. No, certainly. But first time, first time I am reading order of trial court where my lord Wainsbury principle has been
Everything has
taken care of.
Everything has a first.
Yes. It is true that mere filing, my lord, he knows and contradicts. It is true that mere filing of the appeal does not operate as stay, but in the instant case, the circumstances are otherwise. Stay was granted as appears from the record, and such was not duly extended in spite of such petition being filed, order of status quo passed by the Honorable High Court at Calcutta with leave to renew, appeal being at penultimate stage. The action of putting padlock mercilessly tramples upon the notions of rationality, and especially such being put in a place a day before date fixed for hearing. While the question, did the authority have the legal power to do this, might be answered in affirmative. My lord, this is very interesting. My lord, it asks a question, the court asked a question to himself. While the question, did the authority have the legal power to do this, might be answered in affirmative. Then he goes on, the question, did authority exercise the power in a fair and logical way, does not seem to be answered affirmative. This is, my lord, first paragraph, last few lines, my lord. Has the lordship got that, my lord? Then, my lord, hence the court cannot agree to the submission of the learned advocate for the respondent that the estate officer was justified in putting padlock even after having knowledge that the order sought to be executed was put on scrutiny, and such task would soon come to end. Learned advocate for the respondent submitted it was a fault of the appellant that proper prayers are not put forth in time seeking extension of the order, stay, an appellant cannot claim any benefit. Learned advocate for the appellant, on the other hand, submitted the parties had undergone talks of settlement mediation on respective perusal of the order dated such and such passed by the Honorable High Court at Calcutta in CO number. It appears Honorable High Court
was contention is that on a date you took possession, there was no interim order. The coordinate bench, while passing an interim order for a limited period, expressed its or requested the appellate court to dispose of the appeal within that period. And in case it is not disposed of, they were given liberty to pray for extension of the interim order. So they did not do so. And according to you, also that they were taking time in the appeal. They were only interested in prolonging the hearing of the appeal. And nothing prevented you from taking possession since there was no interim.
No order.
And on the day you took possession, on the subsequent date, an order directing maintenance of status quo was passed, meaning thereby you were in possession admittedly. So that status quo ought to have been continued, should not have been varied, and this order could not have.
My lord, in the impugned order, I will formulate the point of law later. My lord, here the interim order was not varied. It is also a ground. Lordship sees the next page, the operating portion, the interim order was not varied. Interim order was not varied. It's just the action was not reasonable, and that is why the interim order, the estate officer is directed to remove padlock.
Yes.
Next paragraph, Lordship takes, just allow me to pray. I respectively say the court finds himself consonance with that view. It appears that the instant case estate officer could have provided one opportunity to appellant to bring back any specific.
What are your points?
Well, now allow me to formulate the point. The first point, if an interim order is not in existence and the situation has changed, the interim order cannot be reimposed. That is the point number one. Point number two, status quo ante. is, my lord, basically an interim order in the nature of mandatory injunction. My lord, there are specific guidelines to be provided. If I have not done something illegal, an order of status quo cannot be passed. This is the point number 2. The point number 3 is, my lord, the conduct, even the conduct of the opposite party from the beginning is also not entitled him to, my lord, seek any interim order or the order of vacating, putting the padlock vacated. And the 4th is, my lord, the padlock was directed to be removed without even, my lord, modifying the existing order of status quo passed by it on 17 June 2000. So these are the 4 major points I am going to argue before your lordship.
Yes.
Now, my lord, first, on the first point, my lord, if the interim order is not in existence, my lord, then, my lord,
yes,
yeah,
yes.
No, tell him.
Yes.
Now kindly come to just a moment, my lord, just a moment, my lord. এটা কোনটা? Oh, my lord. Now, my lord, kindly take 2008 volume 8 SCC 348. May I hand over a copy? এটা কি কপি দিয়েছো? এগুলো কি উপরে কেন লেখা?
348.
Yes, my lord, 2008 volume 8 SCC 348. Other side একটা copy দাও। No, my lord, straight away. My lord, paragraph 17 first. Here, my lord, the case was when the interim order was vacated or not in operation, a sale deed was executed. My lord, paragraph 17 was order of injunction operatives who has to attract provision of rule such and such, invoking inherent jurisdiction of this court. The learned trial judge opined it was so because the court to pass an appropriate order thereunder. The High Court, however, differed with the aforementioned finding of the learned trial judge to hold that no order of injunction was operative. It furthermore held that any transaction carried out in violation of the order of the court is void and would be a nullity. The decision of High Court is based on decision of such and such. We agree with the High Court on this issue. If the order of injunction was operative up to a particular date, technically, the order of injunction shall not remain operative thereafter. The owner of the land, Dr. Bawa, and defendant such and such, thus could have entered into compromise. The effect thereof would be that the said deed of sale was not binding on the appellant. It would be hid by the doctrine of lease pendants as under such and such of the transport of property. Now, on this situation, kindly have paragraph 19. We must also take notice of the fact that even a court in exercise of its inherent jurisdiction under section 151 of the court civil procedure, in the event of coming to conclusion that a breach of an order of restraint had taken place, may bring back parties to same position as if the order of injunction has not been violated. Well, that's very important. Furthermore, paragraph 20, has got lordship. Furthermore, in a given invoke the rule as in such and such, the said principle, however, was been explained in such and such. The observation can apply to the courts in India without any doubt, same time without impeding the discretionary power vested in such and such. However, as in this case, no order of injunction was breached. the said principle has no application. The deed of sale therefore need not be set aside. It will have its own effect regard to section 52 of the Transfer of Property Act and such. So taking the analogy from this case, here injunction order was not operated, and the sale deed was executed in between. So the court says, the sale deed we will not do anything. If they wins in the suit, theory of lease pendants will arise. Now, taking cue from this judgment, if I import in my case, I have taken possession. If they win in appeal, they will get back the possession.
Yes.
Now, as I said, in second 2006 volume 3 SSC 312. The order of status quo is basically a mandatory injunction. Kindly have a look at
2006.
Now before that, kindly have a look at section section 39 of the Specific Relief Act. Specific Relief Act আছে একটা কপি নেই? নেই এরে
Yes, yes.
Number 39. Supreme Court has held status quo ante is interim order which is in nature of mandatory injunction. Now, may I place it, section 13. When to prevent a breach of obligation, which is not there, it is necessary to compel performance of certain acts which the court is capable of enforcing. The court may, in discretion, grant an injunction to prevent the breach complained of. Also to compel performance of the requisite act. So, my lord, I am harping that there is no breach of anything done by me whereby, my lord, a status quo ante, an order in the nature of mandatory injunction can be passed against me. There has to be some kind of breach on my part. So the breach is not there. Now, my lord, pausing here, my lord, kindly have a look now at 2006 volume 3 Supreme Court cases 312. আজকে যাবো না, বডি আসবে না তো দুদিন, পরশু দিন হবে, আজ যেতে পারবো না, ছেলেকে নিতে হবে। Paragraph 5, Placidum H.
Status of the proper status.
Yes,
is to be ID.
And also, my lord, on this, and also I'm going to place the celebrated judgment also on the status quo ante. But before that, my lord, paragraph 5, Placidum H, if your lordship takes. Placidum H, but starts from the but. But, of course, the aspect has relevance only to the extent before ordering an interim mandatory injunction or refusing it, the court has to first consider whether plaintiff has proved that he was in possession on that day of suit, and on that day the order has ordered and he be dispossessed on the next day, unless prima facie finding that the plaintiff was in possession on this days is entered, an order of interim mandatory injunction could not have been passed, and any such order passed would be without any jurisdiction. An interim mandatory injunction, next paragraph, is not a remedy which is easily granted. It is an order that is passed only in circumstances which are clear and the prima facie material clearly justified that a finding that the status quo has been altered by one of the parties to the litigation and the interest of justice demanded the status quo ante be restored by way of an interim mandatory injunction. Keeping this principle in mind, it is necessary to see such and such. So that what I am submitting. He has to find out who were whether there was a status quo order, who was in possession, and then only status quo ante order. Now, my lord, it's the discussion will not be completed without this judgment, my lord. This is the main judgment of my lord of Dorab Swaji Warden, my lord, reported in
1992.
1919 volume 2. My lord, only one paragraph I am.
Section 44 Transfer of Property Act.
এটা ভালো তো উপরে এই দাগগুলো কেন আসে না মানে প্যারাগ্রাফটি না only
In exceptional cases,
yes
interim mandatory
yes well just and also before that well that are the parameters, but before that there is a finding of Supreme Court, a ratio decided by which is very important at paragraph 16, well just paragraph 16, the relief. May I place it, my lord, paragraph 16? Has your lordship got that, matter paragraph 16? The relief of interlocutory mandatory injunction are thus granted generally to preserve or restore the status quo of the last known contested status which preceded pending controversy until the final hearing, and full relief may be granted, or this now very important, compel the undoing of those acts which that have illegally done, not my lord, unreasonably done, or restoration of that which was wrongfully taken from the party complaining. So, my lord, these are, in my humble submission, are the two main tests. First, compel the undoing of those acts that have been illegally done, so which is not applicable in my conduct. And second, restoration of that which was wrongfully taken from the party complaining. That is also I have not done. So, my lord, the main judgment, the law is well settled, but since the granting of such injunction of priority fails or would fail to establish right trial, may God, my lord, this is a different case where, my lord, these follow, my lord. But here I say, I took the position, there was no illegality, and he was also not illegally thrown out of the position. So on this basis, the status quo order is not. So, well, these are these two judgments, and thereafter, well, on last proposition point which I argued, well, the impugned order, lordship will see, well, the status quo order was not valid. If the status quo order is not valid, you cannot, well, just kindly come to the operating portion of this.
I've seen only directing removal of the padlock.
So earlier order has not been. Fourth point, my lord, I have already canvassed before your lordship that their conduct, 30,000 cost was there, but still then they were not diligent.
Yes, Mr. Bhattacharya, how much time he will take?
I have to answer him.
How much time I'm asking you?
Really don't know. 30 minutes, 45 minutes, half an hour.
45 minutes.
He has taken from 3:30 to 4:30.
শুরু হয়েছে
না এবার বল 4:30 শুরু anytime tomorrow, I'll answer. It will take some time. Definitely, it will not take me not by the clock. I can't say 5 minutes. Or there is a possible 3:30.
Yes,
tomorrow 3:30, your lordship keeps it, I'll be if it comments to your lordship. I have no problems with 3:30.
Tomorrow 3 p.m. I have fixed on that understanding.
I'm sorry?
Tomorrow 3 p.m. one matter has been fixed on that understanding. It will continue.
4 o'clock.
That matter will continue if it continues after that.
That depends on the, if there's a 3:30 resolution, they might not be inclined to continue beyond 3:30.
On that understanding,
What?
these matters I am fixing on that understanding.
That they will not do them.
3, 3:15, 4, 4:15. On that
I
understanding.
leave it to the court, anytime tomorrow, whenever it suits your lordship. No, I'll be there.
It's better to do it on Monday.
I know.
No, no,
better do it next
I
year.
am looking after you on.
তিনটের সময় কিছু আছে?
Well, affidavit of service may be formally taken on record.
Service filing code.
Grateful to you.
Grateful, Your Lord. Much obliged.